Good afternoon, and welcome to the Appellate Division, First Department. We have more than 7 hours of requested argument time, so I'm going to ask, as I always do, please keep your requests to the time that you need, not the time that you want, understanding that the court is fully familiar with your case, your briefs, and the record, and typically more than you wish we were. So, and know that the time is for you. So what that means is if you are brilliant and my colleagues have more questions, I let the time roll, okay? So, first case on the calendar, People versus Alvin Dixon. How much time? Submit. Forster versus Forster.
For the account, 6 and 2, please.
Okay. 6 and 1 and 6. A.D. Children is a submit. Pearl Binder versus Pearl Binder. 5 and 2? Okay. 5 and 2 and 6. Bafalco versus City of New York. Okay. 5 and 1 and 5. Holness versus 421 Kent Development. Okay.
Respondent 421 Kent, 6, please.
Okay. You have a cross motion? Okay. So 5 and 2, 5 and 5 and 1. People versus Fabian Brown. Submit. JC and Infant versus London. Okay.
Respondent appellates 5 and 2.
Okay. Do you have a cross appeal? Yes? Okay. 5 and 2, 5 and 2.
The other respondent appellate to London, but I submit also 5 and 2, please.
And you have a cross appeal as well. Okay. So let's, huh? Oh.
Sorry.
Let's do 5 and 1 all the way across the board. And like I said, if you're brilliant, you'll get that second minute. Hudson ES LLC versus First Franklin Financial. Okay.
Respondent First Franklin 5
6 and 2 and 5. H. Jeanette versus John H. Submit. 350 East Houston Street versus Travelers Indemnity. Okay.
Respondent Peterson 4 minutes.
Okay.
Respondent Temple 4 minutes, please.
Respondent Appellate Cops 5 and 2, please.
Okay. 5 and 2, 5, 4 and 4. People versus Jesse Jauko. Okay. 5 and 1 and 5 on this one. Efren versus Efren.
Appellant Efron Film 6 and 2, please, Your Honor.
Okay.
Respondent
6 and 2 and 6. Countrywide Insurance versus National Indemnity.
Appellate National Indemnity requests 5. We heard from Countrywide yesterday that they are not coming.
Okay, so let's get your argument in 4 minutes then, since you have no one you have to fight against. Spicchio versus Starbucks Corp.
Appellant 6, Starbucks. Plaintiff respondent 4.
Okay.
Responded, Eclipse, I'll take 3 minutes, please.
6, 4, and 3. Thank you. Roth versus Velasquez.
Appellants 5 and 1.
Okay.
Respondent 5.
5 and 1 and 5. People versus Sammy Martinez Jaques. Okay. All right. 4 and 1 and 4. So you guys were going to ask for more time. Adab versus New York City Housing Authority is a submit. First case on the calendar, People versus Alvin Dixon. Oh, sorry. Forster versus Forster. You may proceed.
Thank you. May it please the court, Michael Calogero of Cohen, Clare, Lance, Greifer, and Simpson for the appellant Stephanie Foster. Your Honors, this is an appeal of the Supreme Court New York County's order dated October 21, 2025 that was issued in the middle of this divorce trial that terminated the pendente lite spousal support to be paid by respondent to my client appellant pursuant to the prior order of the court that had been issued about 3 years earlier in 2022. Substantive law.
Counsel, was there a change in circumstances here?
Not only was there not a change in circumstances, the threshold to be met on a pendente lite termination application of temporary support is they must establish an even higher threshold of exigent circumstances. Neither was met. At the time of the initial pendente lite support motion in 2022, the respondent affirmed to the lower court that he was retired. I believe his quote was, quote, "Plaintiff knows full well I am retired." He went through his income at that time. In 2020, he was earning approximately $200,000. The year after, in respondent's brief, he only earned about 23 or so thousand.
Had there been any showing of an inability to comply with the pendente lite order?
No, it's a good question, Your Honor. No, there has been no showing of that. In fact, the respondent submitted a statement of net worth in support of his motion in 2025 to terminate the pendente lite support order, in which he averred in his updated sworn statement of net worth, he had $4.5 million cash in the bank available to him at that time. That's not to even get into the LP and GP interests, including carried interests that he had in his private equity firm that he maintained going forward. And additionally, he had an investment vehicle that was an estate planning mechanism known as the Foster Family Limited Partnership. He did not disclose the value of that. A couple of years prior, he disclosed it at a value of at least $4.6 million. On top of that, he also averred that post his retirement, his then retirement in 2025, even though he was already retired in 2022, that he would be earning $200,000 a year in retirement income plus management fees of $200,000 to $300,000 for the remainder of 2025. So to answer your direct question, no, there was absolutely no showing that he could not meet his expenses, which is the standard this court has consistently promulgated, including in the anonymous matter in 2009, that the order must be so onerous as to deprive the payor of income and assets necessary to meet his own expenses.
The trial judge invoked, among other principles, interest of justice. To what extent, in your view, does interest of justice inform the inquiry whether to terminate the pendente lite relief?
I do not believe that the interests of justice result in any different conclusion. In respondent's brief, they try to distinguish between interests of justice and an inability to meet expenses. But if you look at their brief, which we have distinguished in our reply brief, all of the cases they cite where they talk about interests of justice, then when you read the actual cases, talk about inability to meet expenses. Heron v. Azule from this court, reduced on a finding that the award was so onerous as to deprive ability to meet expenses. Stanton, from the second department, reduced payments where they were so prohibitive to strip payor spouse of income and assets necessary to meet his or her own expenses. What I think the court got crossed up or focused on in the quote-unquote interests of justice was the retirement, which again was not a change in circumstances. The economics of it were not changed. In fact, as we point out in our brief—
The court also was concerned that the payments had been going on for quite some time, and that it appeared that, at least arguably, your client is engaging in lots of litigation in order to delay the ultimate divorce trial.
It's a good question. There is absolutely no delay. Let me answer the second piece of it first, and then I'll get to the duration of how long spousal support has been paid. There was multiple motions consolidated for decision in this decision, and the judge actually specifically found that this trial has gone on for an extended period of time because of the unanticipated circumstances that resulted when it was revealed post-note of issue on the eve of trial pursuant to a subpoena that was served on Morgan Stanley that respondent actually had $7 million plus that he had received shortly after commencement of the action from the sale of a portfolio company in his private equity firm, when, at the time of the 2022 briefing, he swore to the court, I only received $300,000. In fact, he tried to take on head-on my client's assertion that he's going to get more than this if he has not already. He specifically said, That's wrong. That's a lie. In fact, he was the one who was untruthful. Let me speak to the duration of how long a spousal support has been paid. The DRL 236 Part B has two separate sections, one for as it relates to maintenance. The post-divorce maintenance section in Part 6, the temporary maintenance section in Part 5A. The advisory guidelines that were promulgated when the DRL was amended in, I believe, 2016, established only advisory guidelines for the duration of maintenance. That only applies post-divorce. For pendente lite maintenance, those guidelines do not apply. Additionally,
One of the things that pendente lite relief is supposed to remedy is that if there's not a speedy trial, right? And if someone is engaging in things that prevent that speedy trial reaching its conclusion, how should we look at that?
So that can be dealt with a couple ways. First off, as I mentioned before about the unanticipated circumstances, to the extent there's any delay, that falls at respondent's feet for his non-disclosure. Secondly, this can all be dealt with in the final trial decision after trial. We say in our brief as well, to the extent the court finds that there's been an overpayment of spousal support, either in duration or amount, they can reallocate and give credits for overpayments. I see I'm over my time. Thank you, judges.
May it please the court. Good afternoon. For the defendant respondent, Mr. Foster.
Counsel, I noticed in your response brief, the issue of whether or not he was retired in 2022 or 3 years later, you kind of danced around, well, maybe you, I don't know, but someone danced around that issue. Do you want to address that now?
I'm delighted to address that. Thank you for the question, Your Honor. There was no dancing. Mr. Foster in 2022 indicated to the trial court that he was constructively retired already at the age of 79, a really important fact that notably plaintiff appellant makes no reference of at all. At the age now of 83, nearly 84, as the motion papers and the record below reflect, Mr. Foster, for the first time, in fact, is involuntarily retired. Unbeknownst to him in 2022, he was subsequently allowed to
He was
participate.
involuntarily retired, not because of some physical inability, but
Correct.
because of the issues surrounding the divorce.
I believe you, correct, Your Honor. In fact, I believe what you mean to say is plaintiff's terrible
No, I know what I
choices.
mean to say.
No,
Please don't.
no, I'll
please
say.
don't do that.
Respectfully, Your Honor, I understand. I will say, Your Honor, that the loss of Mr. Foster's management fees and his employment, in our view, although the trial court did not opine, resulted directly from the plaintiff's engaging of a public relations counsel, Mr. Lanny Davis, who she testified she paid money to place articles in the New York Post, including to embarrass Mr. Foster and his private equity firm. It's no surprise that Mr. Foster testified on May 29, 2025. There was a reporter in the courtroom. He was asked to retire the next day, or pardon, the next day the New York Post had another article taking direct aim at Mr. Foster and his ability to earn money. And the following day, effective June 1, Mr. Foster was asked to retire. He did not, at 83, he was entitled to retire voluntarily, but that's not this case, Your Honors. In fact, Mr. Foster was continuing to work, albeit in an emeritus status. In 2022, he indicated to the trial court that he was participating in 2 calls a week and occasional conferences. At this point, he doesn't even have figurehead status. He's off the website. He has no formal relationship
Counsel,
any longer.
can I
Yes, Your Honor.
get back to the standard, whether or not your client can meet his own reasonable expenses? And it looks like your friend just stated that your client had $4.5 million. Why isn't it simple? If he has $4.5 million in the bank, why can't he meet his expenses on pendente relief?
So I have there's a 2-part answer to that, Your Honor. First, that's actually not the standard. This court has repeatedly indicated that exigent circumstances, including a catch-all interest of justice, is a perfectly reasonable basis for the trial court to...
Exigent circumstances,
Correct.
actual interests of justice.
Yes,
Those
Your
two
Honor.
don't equate. I'm sorry.
They do, Your Honor, actually.
No, they don't.
So in the event that there is not a speedy trial, and I think both sides concede that at 2 years into trial, while we remain in plaintiff's case in chief,
And as your adversary pointed out most adequately, Part of that delay is hiding your assets. And when you do that, that delays the trial from going forward because now we have to engage in discovery again. So you own that. Your client owns that.
My client disputes this entirely, we believe, incorrect assessment by the trial court, although we understand that the trial court determined that he had not disclosed the specific accounts. The record reflects in February of 2022, Mr. Foster in fact disclosed that he was being allocated $7 million in connection with a post-commencement sale of a private equity fund. That money was left in the business. He disclosed that that money was being distributed, that it was allocated to him.
When did he disclose the $1.2 million, I believe, in management fees? When did he disclose that?
He disclosed the management fees, Your Honor, only when it was time for, truthfully, at trial, because the management fees started
Really?
post.
That's not income?
It is income. But, Your Honor,
I thought income was required to be disclosed as a part of the discovery process in a matrimonial action. No?
respectfully, Your Honor, in 2022, my client disclosed that for the prior 3 years, he did not have management fees or income greater than $200,000. His management fees began after a new fund launched in 2023 and 2024, and that's when he began to receive management fees. There was no opportunity to disclose those prior to the 2024 statement of net worth and preparation for trial. We disclosed his tax returns along the way, but the fact that during the pendency of this litigation, Your Honor, our client had the benefit of being extended participation in a new post-commencement fund that generated management fees is not something that was hidden.
I know your red light's about to go on.
Thank you.
Why isn't the remedy of an offset or credits on the equitable distribution award an adequate remedy here?
So it's a good question, Your Honor. Thank you. So I want to say two things, and I didn't get back to Justice Hagler's. But as a start, Your Honor, I want to remind the court that this court has repeatedly held that it will defer, to the sound discretion of the trial court. You rarely disturb maintenance decisions of the trial court. The trial court that has presided over this 2-year-long and running trial has determined that the balance of allowing plaintiff additional witnesses after she moved in the second year of trial for 16 witnesses, additional, 7 witnesses, additional, all designed to prolong her ability to continue receiving spousal support. The trial court judge is in the best position to assess what the right remedy is for these people. The $4 million. All right, thank you, Your Honors, appreciate it.
Thank you. Briefly, I'll just.
1 minute.
Thank you. One thing, additional piece on the inability to meet expenses or lack thereof of that is that respondent also acknowledged he spent imprudently and irresponsibly during this action, including buying an $800,000 boat and $80,000 vintage Ford Mustang for himself. Counsel talked about how rare it is to have maintenance determinations disturbed on appeal. The truly rare part is to have pendente lite support determinations changed on appeal. Exigent circumstances, we've covered this, are exceedingly rare and can be remedied at the end of the case. The last piece I would say is I would encourage the court to read the record from pages 85 to 90, which is what respondent cited and claimed that my client testified that she had articles placed in the post. If you read the testimony, that is not what she testified to. Unless the court has any other questions.
That's not your strongest argument. So
Thank you.
I wouldn't have ended on that.
I appreciate
But
it. Thank
all
you.
right.
Thank you, Judge.
Pearl binder versus pearl binder. Counsel?
Good afternoon. May it please the court. My name is Becky Beck on behalf of the appellant. So this appeal concerns a narrow but significant procedural error in a dissolution proceeding involving a multi-generational real estate portfolio worth hundreds of millions of dollars. So the question here is whether the motion court properly entered a final order of dissolution that adopts an order of appointment of receivership, directing the receiver to immediately liquidate by asset sale the portfolio absent any evidence, any request of the parties, any supporting documents, or even procedural safeguards or a mechanism for judicial review put in place before the irreversible sales take place. So here, there is no disagreement on the fundamentals. We are the petitioners. We petitioned for a dissolution. We requested liquidation. That's what happens in a dissolution. We requested the appointment of a receiver. That is because this portfolio is very complex. There are S corps, C corps, LLCs, partnerships. Some of them have properties, some of them don't. Many of them are in disrepair, disarray, but a valuable portfolio altogether. And so the parties agreed that a receiver who is capable, who has knowledge in this field, in this area, is the right person to go in there to look at the financials, look at the data, look at the rent rolls, look at the mortgage statements, all of those things, take a hold, get a grasp on what the properties are worth, what is going on in the entities, and take control of that, and then present to the court a plan of final liquidation, which the court could then either approve or not approve, but critically would give the parties then an opportunity to object or respond or put in evidence saying, no, we think that's wrong, we think that's right. All of that was short-circuited. The court cut the receiver's legs out from under him effectively by directing the method of liquidation and the timing of liquidation by saying that the receiver must forthwith marshal and liquidate the assets. So that
Did
means
the judge offer a reason for directing what I'll call a prompt winding up as opposed to the imbue the receiver with discretion approach?
so the only thing that is in the record is in that footnote 1 that is in the order of appointment of receiver. And that's because there really is no record. There's a petition, there's no opposition papers, there's no answering papers, there's no motion papers, there's nothing. There's no affidavit, there are no fact affidavits, there are no client affidavits, no sworn statements. So the only thing that's in the record that the court, or where the court is expressing the basis for which the court believes an expedient and immediate sale is proper and necessary, is in that footnote 1. And that footnote 1 is, I can tell you, I'm sorry.
Would it be fair to say that the judge was actively managing this dispute, though?
Actively managing the dispute.
Conferences and the like?
There certainly were conferences, but the conferences did not, it didn't involve an in-depth discussion of what liquidation means here, right? And the typical process is to, in a complex receivership, is to let the receiver do that, to come up with the plan, to look at all the information and present to the court what the receiver thinks makes sense here. And here, that didn't happen. The court ordered a a liquidation by immediate sale without giving the receiver even an opportunity to look at any of the information.
Wasn't that based on the agreement, in essence, that the letters that the parties submitted to the court, saying, these are the two proposals here, you pick one, and the court picked one?
So the joint letter,
Yes.
and the proposed red line order of receivership, right? That order, or the letter rather, was the parties were directed to submit a proposed form of receivership order, again, very typical, right? And usually, and the motion court himself said, these things are usually pretty standard. It's, what are the authorities that the receiver have? Can he, hire tax counsel? Can
The
he?
point is, you were provided an opportunity to submit one, and you did.
To submit an order of appointment, yes, which we did, and my adversaries redlined the order, yes. And so the portions of the order that we are not contesting are the ones that deal with the management, the authority, the authorization that the receiver has. But the problem, the issue, is that that order then contained substantive relief that was not requested by the parties, that was not formally requested by the parties.
All right, you'll have time on your button.
Thank you.
Good afternoon. Adam Stein for the respondents. Appellant has been seeking an amorphous tax structure ever since new counsel came in, but I must stress to the court that this action, which was started by the appellant, sought in their order to show cause underlying this action, quote, an order liquidating each entity's assets until such time as the entities are dissolved, close quote. in multiple attorney affirmations in the record that appellant submitted in support of this order to show cause, the appellant's attorney wrote in a sworn affirmation that they want an order, quote, appointing a receiver to wind down the affairs of the company, liquidating each entity's assets until such time as the entities are dissolved. In appellant's over 100-page verified petition, she stresses the urgent need for the entities to, quote, promptly be dissolved and wound up because the entities are no longer capable of continued business operations due to inter alia, discord and dissension, breaches of various agreements, voting deadlocks, and other inaction, financial unfeasibility, and frustration of business purposes, thus requiring dissolution, quote, record at 29.
Counsel, is that why the parties submitted that joint letter to the court, each one presenting their own proposal as to how this matter should be liquidated?
Exactly, Your Honor. We came into court after appellant filed this proceeding saying that they want liquidation because of all of these reasons that the company's failing. We agree the company was failing and is failing, so we wanted to streamline because we recognized that it wasn't possible for these companies to continue for lengthy periods of time. So we said, we consent to liquidation. And as Your Honor pointed out, we had multiple hearings, conferences in front of the judge where predecessor counsel could have said any time, we want something other than liquidation. We want some tax-efficient strategy. We want the receiver to have discretion. Nobody ever said that. And I think the timeline here is really critical because, Judge, why did they seek a stay? If they really had a problem with this order, they knew the minute this order comes out, the receiver goes forthwith, liquidation, 6 months. No appellate brief, no stay. Now, we're well into the process. So what are we going to do? We're going to unwind everything and retroactively say, it just can't be done.
Was the form of the receivership directed by Justice Cohen unusual? Is it more common, as your friend indicated, to appoint a receiver who has discretion in the manner in which to wind up the affairs of the business entities?
Your Honor, not only is the order that Judge Cohen signed highly typical, but I haven't seen, no one in my office has found any case law that would suggest that what the appellant is asking for is even remotely doable, let alone has ever been done on any level in a dissolution case in New York. And I must add that based on the letter of the law and based on the appellant's filings, they don't have standing to appeal this because they are appealing exactly the relief they asked for in this case. They asked for, in the underlying petition, an order of dissolution and liquidation. The judge said, we'll have some disagreements about the language, submit competing letters. He chose ours.
So, counsel, to be fair, in the letter that they submitted, didn't they ask for a tax-efficient property division, and that was denied by the court?
That's correct, Your Honor, and
Why
I'm glad.
can't they appeal that?
And I'm glad you asked that because in that letter, first of all, now the appellant is complaining that they didn't have any evidence or any time to submit evidence. They could have put evidence in the letter. They could have put an expert affidavit from a tax professional. They could have asked for a hearing. In one of the conferences, the judge said, you know, there's a possibility for a hearing, but both parties agreed to do it on submission. So there were plenty of opportunities to make evidentiary submissions. They've been arguing for liquidation since June of 2024. They had numerous opportunities along the way, including December 18, 2024, the judge entered an interim order of dissolution. They didn't seek re-argument, stay, appeal, nothing. Nothing, they let it go. They never said a word about a tax-efficient structure until almost a year after this action was filed through new counsel. The court had never heard of it. We had never heard of it. Appellant said nothing. Appellant cannot now, mid-dissolution, mid-liquidation process, with no request for a stay, come into this court and say, you know what? We think the judge got it wrong. We want the process to be reversed. We want tax-efficient structures. The whole point of this case is that we can't work together, meaning we, the underlying clients, we can't be in a business relationship. So how could we be in tenancies in common, as appellant proposes, where we're in forced agreements during this quote-unquote interim period? It literally cannot work. It's impossible. Your Honor, I urge the court to affirm Justice Cohen's sound ruling. Thank you.
Thank you. Well, the first thing I wanted to say was, Mr. Sines said that in answer to Judge Hagler's question about the joint letter, whether we requested a tax-efficient plan and Justice Cohen denied that request. That is not correct. We proposed a tax-efficient plan as one of the ways that liquidation could take place, but ultimately deferred to the receiver to come up with a plan to present to the court for then comment by the parties. And that is what our form of proposed receivership order also reflected, was a final report and recommendation from the receiver. We were not asking Judge Cohen to endorse our specific plan.
Well, but the judge could have selected either of the proposals that were made to the court.
Well, in this instance, because there was...
Your proposal keeps the court's hand in this process, right? They have to then you have to come back to the court with the proposal. The court has to reevaluate. And who's the expert? The whole reason for having the receiver is to have someone in the field who is on the ground and understands the market at the moment that these properties are at sale. So,
Sorry. That's absolutely right. No,
right,
you're
but the
absolutely
judge made a choice. Why should we undermine that choice?
The judge made a choice based on advocacy, but not based on evidence. So he heard from the parties in a letter, but there is no evidence.
What evidence did you request to submit? Did you ask for a hearing for the submission of
We did
evidence?
not ask for a hearing.
Did you ask to submit a memorandum of some sort or an expert affidavit, as your adversary said?
We did not. But
So then why should we undo, just as you are asking for the unwinding of a lot of hard work.
Your Honor, respectfully, we are not asking for the full unwinding of all that hard work. If I may just
Just
finish
some
my
of it.
sentence. Yes, it is that we
You
just
have 30 seconds.
want to modify that portion of the order that directs a sale before the receiver can evaluate and then present the final plan of dissolution. The receiver can continue to manage the properties, to take hold of the entities, et cetera.
Got it.
Thank you.
All right. Folco versus City of New York. You have 5 minutes.
Thank you, Your Honor. Good afternoon, Your Honors, and may it please the court. My name is John Scola. I am here on behalf of 3 NYPD sergeants, Ida Bifalco, Brent Curry, and Scott DeFalco. This is a case, an Article 78 appeal, where my clients spent their whole careers essentially studying for this lieutenant's exam. They take the lieutenant's exam, they pass the lieutenant's exam, and then their scores are ultimately nullified and not considered. DCAS is the one that created this problem. Originally going into the examination,
Were the instructions unclear?
No, they weren't clear.
So the instructions were very clear that you cannot take out, use, or display in any way a cell phone in the examination room.
That's
Now,
incorrect.
it didn't say during the exam, it said at no point in this room can you take out a phone.
Incorrect,
right?
Your Honor. That's incorrect.
That's incorrect.
The rule said that you cannot bring your phone into the testing site at all. When they got to the test examination, they were given a plastic bag from DCAS and told they could bring in the phone into the test site. DCAS changed
And
the
put their
rules.
phone inside the bag and put it underneath.
Your Honor,
And not
chair.
use it.
Your Honor, them giving them the plastic bag already violates the DCAS rule. They changed the rules when they gave them the plastic bag.
Did the plastic bag say you could open it before you leave this room?
No, Your Honor.
Okay.
The plastic bag also
Are
said...
you telling us that they were unclear, that they were not supposed to use the phone?
Because I don't even think that they're saying that.
It is unclear, 100%, that's what I'm saying. When they got to the test site, they were giving a plastic bag and
I
told
thought that when at least 2 of them indicated that, yes, we knew we weren't supposed to do this, and I'm paraphrasing, but please, we're falling on the sword here, right? That's kind of
No,
what
Your
they
Honor.
said. It's not?
I don't believe so, Your
Oh.
Honor.
You read it all wrong.
Okay,
Go
so,
ahead.
sure. So there's no, it's crystal clear that the rules say you cannot bring a phone into the examination. When they got there, DCAS provided them with a plastic bag and said you can bring a phone in. At that point, the rules are basically voided. They changed the rules. My clients relied on what DCAS did, which is bring a phone in. They didn't use the phone during the test. They didn't use the phone after they were done. They waited until they were told that the test was over. DCAS states in their papers that there was...
Right, and okay, so let's jump to that point where there may or may not be an issue as to when the test concluded. Did DCAS somehow seek to remedy, there's no 5-year ban anymore, correct, on them retaking a civil service exam?
Yeah, so the original penalty was not to score the test and a 5-year ban. After they appealed that decision, they removed the 5-year ban, but they didn't score the test. The effects of that is that they'll never get promoted to lieutenant on the NYPD. You have a finite...
We have no way of knowing that.
Your Honor, the tests come every 3 to 5 years.
We have no way of knowing that.
You have no way of knowing that.
So
opposite.
unless your officers are on the verge of retirement, that you can say that. This is a speculation argument. They are free to take the exam again when it's offered. They are free to apply.
It's not that simple, Your Honor. These tests come up there's not a test every 2 months. They exhaust the list and then they can reapply at that
You think
time.
we got here not knowing these things, counsel?
Your Honor, I didn't say you didn't know.
Good, I'm glad, because you should talk to the court as though we are familiar with how the city runs. You think this is our first police officer case?
No,
Okay, so
I've argued
please.
others before.
Okay.
Yes.
All right.
But that being said, they still come every 5 years. My clients are in the upper limits of their career, and by the time it comes around, it's unlikely they will be able to take it and pass it or be on the job to get it promoted. But the fact remains, the trial court erred in applying the wrong standard to a motion to dismiss. They did not apply the facts taken in light in petitioner's light. My client explicitly states in his affidavit that he saw other people using the phone. There was selective enforcement. My clients were the ones that were disqualified.
Was there anything more specific other than that allegation of selective enforcement? Were there this person, I saw this particular person doing something, or was it just other people were allowed to do it?
So all these clients are sergeants in the NYPD. The sergeant in the NYPD saw another test taker directly use their phone. That's stated in the affidavit. There's nothing that rebuts that no one else used their phone or anything to the contrary in the respondent's papers. On a motion to dismiss, there has to be a fact-finding hearing or some type of developed record. The court has to take what we say is true. If we take what we say is true, other people use their phone and they were disqualified. That's the definition of arbitrary.
Thank you.
Thank you.
May it please the court, Ian Sinclair for respondents.
So, counsel, what's the rule?
Thanks for that question. So there are two separate rules, petitioners conflating them. There is a rule that stated that you are not allowed to bring cell phones into the site. There's a separate exam instruction that your honors were referencing that it's a distinct requirement that says before, during, and after your test, you are not permitted to use, have turned on, or have out in the open cell phones.
Now, that second rule, were the petitioners advised of that rule?
It's a written exam instruction, and at nowhere in their letters to DCAS, at nowhere in the petition, none of the motion papers below did they say we didn't read this exam instruction. So it's taken that they, in fact...
Did the petitioners say that we were aware of the rule, granted some leniency?
Two of them said something to the effect of that, while phones may be prohibited in certain areas, one said, I carelessly took out my phone and I acknowledged that it was careless. One of them didn't.
I was waiting for an emergency phone call from a spouse or something involving a child. Like they had reasons.
Broadly speaking, they were each saying a version of, I had a good reason to check my phone, or I didn't realize the exam was over. That was the sum and substance of the three letters that were submitted to DCAS.
Question, when is the exam over? When the party finishes the exam, or when the proctor says the exam is now over?
That is not in the record. I would imagine it's when the proctor says the exam is concluded, but that wasn't part of the discussion.
Is that the rule, though? Is the rule, so in other words, is the rule you can't bring out the phone, use the phone until the test is over, or until you're out of the exam room?
The rule that is cited by DCAS doesn't stipulate that specific answer. It just says before, during, and after your test, you are not permitted to use, have turned on, or out in the open cell phones.
But okay, Now I'm gonna play devil's advocate.
Please.
So if it says, read that again.
Before, during, and after your test, you are not permitted to use, have turned on, or have out in the open cell phones.
Okay. So before, during, or after? So does that mean you have to be out of the exam room?
That's,
Because after, I'm out on the street. You can't tell me I can't put on my phone out on the
Yes,
street.
of course.
So the after has to mean outside of the exam room.
Sure, yes.
Is that clear?
I mean, it's certainly inferable, I think.
No, when you are barring someone from being able to take an exam and not grading their exam because of this violation, shouldn't that be clear?
I think the fact that they had them put the phones in sealed plastic bags underneath and inaccessible.
But why is his argument then not fair game when the rule says you can't have it in here at all, and then you provide me the means to bring it in here?
The plastic bag is.
I would just add to that, if you're saying until you finish your test, does that mean your test or everyone's test?
It doesn't say your exam. Oh, it does say, I'm sorry, your test, yes.
I mean, you read it, that's why.
It's getting more unclear by the minute, my friend.
So now if I finish my test, I'm done. I'm free from the prohibition,
rule.
from the rule, which is what they are arguing. They're saying, we finished our test. We don't have to now not
What they actually,
to our phones.
sorry, Your Honor. What they say is that the exam had concluded. But either way, it says before, whether it's one individual or every individual, it says before, during, and after.
But again, when is the after over?
You take it literally, they can never use their phone again.
Right. So I mean, like I said, once they're out of the building,
That is
you
how DCAS,
cannot tell me I can't turn on my phone.
and that's how DCAS
But
construed it. I'm sorry.
Counsel, that instruction is not clear.
We think that the fact that the exam instructions state quite broadly that you can't use your cell phone at any point makes
Friend
clear.
would say one of the rules said you can't bring your cell phone into the test room, test area, and yet they were given a plastic bag in which to place their phone in the test area.
Right, which is a separate rule, and they were not accused of violating that rule, and that's why the conflation is not relevant to this case. The fact that DCAS recognizes that people bring their phones everywhere, and they don't want to bar people simply because they can't leave their phones at home or in the car or wherever, they're allowing them to take the test so long as they don't use their phones.
But if you use the phone on the completion of your test, where's the violation? Where is it? Because they're not being accused of using it during the time they were taking the exam. Can we agree that all three people had finished taking their exam at that time?
Since they allege that, yes, we'll accept that for this purpose of this appeal.
But there's no evidence to the contrary, nor do you allege it. So why this conditional, for the purposes of this argument? Either they were finished with their test or they weren't.
Well,
You would know that.
I'm going based on what DCAS's determinations letter said, which was that the test conclusion was ambiguous or unclear.
But that's why I asked you, who determines when the test is over? Is it when I finish my test, the test is over for me? Or is it when the proctor says the test is over?
Based on the DCAS determinations, I understand it to be when the proctor says the exam is over.
You have to be clear, and the rule has to be clear on that. Because otherwise, we're penalizing people for not following a rule that is really not clear.
I appreciate that statement, but we don't think, the broadness of the rule, we think the Supreme Court got it correct, that this is, you can't say that this was arbitrary because they all conceded to having pulled their cell phones out in the exam room, which is
in the exam room.
See, you keep on changing the goalpost, and it seems like that has happened in the application of this rule. Just the way you're arguing it, you keep on changing where the center is, and that's not fair. How do they comply with the rule if they're not clear on what the rule is? And it doesn't even seem that DCAS is clear on what the rule is.
I don't mean to change our position. What we wrote in our brief, which is correct, and what DCAS interpreted, is that the rule says you can't use your cell phone before, during, or after the test.
No, that's not what you said. Is it after the test or after your test?
This says after your test. They interpret that to mean the conclusion of the exam. They all admitted to using it in the exam room. And because of that, they never contested the fact that they violated this specific exam instruction. Thank you.
Should we be?
You might want to
Made me laugh.
rest.
You know what made me laugh? That wasn't fair.
Who gets to determine the conclusion of the exam?
So
Who gets to determine that?
So in this case, my clients finished early. DeFalco sat there for an hour until the proctors announced the test was over, at which time he pulled out his phone. None of them used it while other people were taking the test. Only after when they announced the test was over did they check their phone to see what happened. Back to the beginning here, though. DCAS can't pick and choose what rules to follow in the test. They can't say, you can't bring your phone in, but here's a bag, bring your phone in. They can't say, you can't use it till after your test is over.
Can we agree that the issue isn't the bag in the phone, it's the conclusion of the test, or are you guys arguing both?
I think it's both, Your Honor, because if DCAS is going to pick and choose which rules of theirs to follow,
But
it's arbitrary.
if they had not, to be fair, okay, if they had not provided these test takers with the bag, then we'd have a much larger group appealing because they would not have been allowed into the exam.
My clients were left.
So it seems to me that the second part of your argument has the most teeth. Can we agree on that?
They're both relevant, absolutely. But my clients wouldn't have brought the phone in, they didn't have the bag. The rules were clear. I mean, they gave them the bag, they brought it in.
They wouldn't have been able to get into the exam either.
Well, I'm saying they wouldn't have brought their phone into the exam. They would have left it out in their car or wherever they would have. They got into it. They gave them the bag. Then they brought it in.
We got it.
Thank you, Your Honors. Have a great day.
Okay.
Oh, boy.
Wholeness versus 421 Kent Development. You may proceed.
Thank you. Good afternoon. May it please the court. My name is Eartha Jean-Baptiste on behalf of Universal Services Group in this matter. In the underlying case, the plaintiffs assert two main causes of their accident. One, they were using a scaffold that was not tied. The second, the scaffold fell into a duct opening. None of that had anything to do with Universal Services' role at the subject premises. Universal Services was a roof contractor. Their purpose was to install the roof. Once that was done, a separate contractor would come in and cut in the ductwork opening.
Counsel, how do we interpret the language in the universal contract arising out of or connected with? Is that really broad contractual language? And I think there's something further down that says, or in the vicinity of.
I think that the indemnification language is quite clear, but that doesn't lend liability to Universal. One, it did not arise out of Universal's work at the subject premises. It arose out of the work of the subcontractor who opened the duct. Pardon me?
How do we know that? Here, on this record, no one admits putting the blue cover on the roof. Nobody, not one party here admits that they did the blue cover. Somebody put it on there, and you're the roof contractor.
Judge, there's testimony that a contractor, Wonderworks, was responsible and used blue skin, the blue covering, on the roof surfaces. There is testimony stating that.
Who?
Wonderworks. There's testimony from multiple parties that Wonderworks, they were the contractor who...
I thought your witness testified that if Wonderworks asked you to put the temporary roof covers there, you would have done that.
So long as you got paid.
The temporary roof covers and the blue skin are not the same thing. The blue skin was the purpose of waterroofing. The temporary plywood cover...
And roofing doesn't waterproof? I thought part of the roofing work is to waterproof. That's the whole point.
Generally, we as Universal did both roofing and waterproofing work. At that specific subject project, Wonderworks was responsible for the waterproofing aspect of that project.
Except there is, as my colleague just pointed out in the record, evidence that your client would do that work if asked to and paid to do it. So we don't know at this point, seeing as no one admitted to doing this particular blue skin, we don't know who did it.
Yes, Judge, but the crux is if asked, but we have testimony that was certain that Wonderworks was the one who in fact did it, right? It's one thing, like if we were,
Who said that
there are
WonderWorks?
multiple, I believe it was the contract,
It wasn't WonderWorks.
It wasn't Wonderworks, but all the other contractors testified that the blue skin was primarily and only used by Wonderworks. They did it. Like, they were the only ones who used it at the subject premises. They were the only ones responsible for waterproofing at the subject premises. The record repeatedly stated that Universal was only responsible for placing the roofing. Then once they placed the roofing, the ductwork would be open. Then another contractor would come in and put the HVAC in the system. And then Centrifugal would inspect the hole to see if it's wide, if it's safe, if someone could fall through. And then once that was done, WonderWorks would do a second inspection to determine the degree to which it needed to be waterproofed and the degree to which a temporary plywood covering would have to be placed onto that hole. In addition, WonderWorks did not proffer any testimony that at any point in time that they instructed Universal to place any type of covering as was required by the
Counsel,
contract to the wall.
Isn't it true that you did not provide the records that would back up the assertion that you didn't place the covering on there? There's no records that would, one way or the other. How would you remember without the records?
Judge, it wasn't the remembering, it was the testimony, right? There was testimony as
My
to
point is,
which
there's
role-
no, you're missing the business record that would actually support what you're saying.
Right, Judge. I cannot testify on the business records that we do not present and we don't have at this juncture. I could only testify as to the testimony that was
Right,
offered.
but it's quite conspicuous that it's only those records that are missing.
Judge, respect.
So the fact that those records are missing and your clients and all these workers have such clarity of memory about this leaves a question.
But Judge, however, our client wasn't the only one who testified that Universal was responsible for, that WonderWorks was responsible for placing the blue skin. There are other entities who testified that also WonderWorks was responsible for placing the blue skin. So it wasn't only the testimony of our clients. The other entities also
Counsel,
testified.
isn't it also true that you had an obligation to inspect the roof? So even if you didn't put it there, you still would have responsibility to make sure it was safe for workers?
Generally, but at the instruction
Not generally, that specifically, it's in the contract.
Yes, Judge, but again, the accident didn't come out of unsafe conditions that the roofing created.
I'm sorry. They have to have a scaffold to create a metal beam hold for a HVAC system. That roof better be secure enough and better have a safe condition. I'm still talking.
No, yes, it's fine,
Okay.
Judge. This is me just not.
So I disagree with you, and you'll have time on rebuttal.
Noted,
Your light
Judge.
is-
Thank you.
Thank you. Who's next? Okay, and you asked for Ivan, your,
6 minutes,
6
Your Honor. May it please the court.
I don't think I gave anybody 6 minutes, so 5, go ahead.
Oh, okay. May it please the court, on behalf of defendants, third-party plaintiffs, 421 Kent, Gin Development, and WonderWorks, like to get right into it. It's clear what Universal's purpose was at the site, and it's a contractually statement that is actually broader than most construction contracts that I've seen in case after case. The language states that Universal also agrees that, quote, the prevention of accidents to workmen, doesn't say universal workmen, to workmen engaged or in the vicinity of the subcontractor's work is its responsibility. So just on that language alone, it has accepted the role of safety guide on the roof. There was a site safety company on the site. It is a party also. It's not involved in this appeal. But
Just to jump in, because I just have, your adversary indicates that everyone knew that WonderWorks placed this blue skin on the roof.
that's not accurate, Your Honor. And the prime statement about that by the appellant refers to the record, page 2888. I have that record. It's the testimony of Edward Power, the principal of Universal. If I may read from briefly from line 8. Question, also based on its position and apparent use in this photo, defendants B, can you say who is likely to have placed the blue skin in that location? Answer, no. Question, could it possibly have been the ductwork installer? Answer, it could have been. Question, is there anyone else that you can think of specifically, same question, any other trade that you can think of that may have also had the need or responsibility to place the blue skin in that area? Answer, Wonderworks. That's hardly a statement that that company installed that blue skin. The questioner was asking, could you guess, could you name some other company that may have done it? I mean, I could have done that because I know the companies that worked at the site, but I'm guessing just like this gentleman was in the deposition. So that testimony holds no weight at all.
Not only did they point to Wonderworks, they pointed to other subcontractors.
That's correct.
As someone, some other entity that would have used the blue cover.
That's right. There has been no acknowledgement by any of the contractors. There's been no evidence that a particular company installed the blue skin tape. There has been pure conjecture, like the appellant's client, that it may have been Wonderworks, the general contractor. Wonderworks witness denied that. Then we would love to find out who did the blue skin because they're a part of the case. But even aside from that, whoever placed the blue skin, and I think, Your Honor, you touched upon it during appellant's argument, there's still an ongoing obligation. Whoever placed the blue skin, whoever created that roof penetration, still, that doesn't relieve, just because, well, we didn't do it ourselves, it doesn't relieve the duty of Universal to monitor the roof. They had workers on the site. They had generally 5 workers on the site during that time frame. The manager who spoke, Mr. Power, said, I'm on site 1 to 3 times a week. After this accident occurred, he was up on the site with another manager of Universal to investigate the whole area, to check for any defects or problems, or to find out what happened with this particular scaffold and see what could have caused it. That's his own testimony. He was up there for a purpose. He understood that it wasn't his worker that was injured. It wasn't his workers that were putting up the scaffold or hanging that beam, but he was still realized that he had a duty to see what happened and to see whether there was something that could have been done to prevent it, and to do so in the future. The contract with Wonderworks, the testimony mostly by Mr. Power that they were responsible and did take a role in inspecting, walking around the roof, seeing if there was any defect or hazard, proves that at least that there is evidence that should be considered by a jury as to whether or not they were possibly negligent and in breach of their contract as well.
Thank you.
Thank you, Your Honor.
Counsel? No, you go.
Good afternoon, Your Honors. If it pleases the court, my name is Michael Reagan. I represent Metropolis. I'm having difficulty saying that. It's interesting. I'm a fifth-party defendant. The fourth-party plaintiff didn't oppose my motion. The only party that's opposed my motion is Universal, and to my understanding, they don't even have claims against us. But right to the point, everyone is talking about this blue skin, and we did so in the underlying motion papers, and I'm a little bit disappointed in myself that I didn't realize until I got on doing the appeal that the blue skin had nothing to do with this accident. I refer Your Honors to page 395 in the record. You can clearly see that the roof surface, the wood under the blue skin, broke, and is a much larger break in the surface than the tape. this has nothing to do with a thin blue skin membrane.
Didn't it mask whatever was underneath it?
No, Your Honors. What it is okay. So when they go in, there's a hole is left in the roof covered temporarily.
It's going to take a little longer for you to explain that. Let me ask you the question like this.
It's very yes. I'm sorry, Your
Go
Honor.
ahead.
No, I'm sorry. Please,
Oh, please.
Your
You
Honor.
want to say it your way, so go ahead.
I don't, Your Honor, and I ask you to please forgive me, and I will take your question.
They open a hole in the roof in order for mechanical equipment to come up and out, HVAC, et cetera.
Correct.
Right? And until that equipment is put in place, it has to put a covering in order to create a water barrier so that there's no leakage into the building, correct? The entire record said that. You have to agree with that.
Well, maybe I'm misunderstanding, Your Honor.
Okay, so if you make a hole in the roof and you're not able to do the HVAC system that day, you have to cover the hole. And you have to make it waterproof so that should something happen overnight, rain perhaps, it doesn't penetrate into the building. This is like basic. And the record is replete with this, with what I am describing.
Yes, Your Honor, there are pre-existing holes left by the roofing contractor that are covered with plywood. Then the HVAC contractor comes in, removes the temporary covering, and places the HVAC into the hole, but it's not a perfect fit. There's a 1 or 2 inch differential between the edge of the roof, okay, and the HVAC unit. That protection is, well, regardless of whether it's Wonderworks' responsibility or the on-site contractors, the testimony of all the witnesses is very clear that it has nothing to do with the HVAC installer. As a matter of fact, the contract that Centrifugal entered into with Wonderworks, the bid package schedule of value says, and I quote, "Centrifugal is not responsible for costs associated with protection of existing and/or new conditions affected by its work." All the testimony is very consistent. The HVAC contractor had no responsibility to provide any type of waterproofing protection. The only waterproofing protection that was responsible for under the HVAC contractor was waterproofing for the ductwork sleeves, the ones that quote unquote were capable of sweating. And they put something called an aluminum jacket on that portion of the HVAC work, which is about 10% of all of the work. But importantly, none of that went on the roof surface itself. But I'm digressing because the main point is Your Honors can look in the record and see for yourselves. This is a thin piece of blue tape, and the roof surface itself, the plywood underneath the tape, is broken 3 inches past the line of the tape. And it's just really goes with common sense when you think about it. This is a very thin blue tape membrane. That scaffold itself with the wheel, that created 4 points of contact. There was 500 or 600 pounds on that scaffold before they picked up that pipe, okay? Of course, a piece of tape isn't going to hold 500 pounds. It was only thereafter when they picked up the pipe and the weight went to like a massive amount of weight that it was too much for the plywood covering, and it was the plywood that broke. The blue tape, this is a red herring. The blue tape had nothing to do with this accident. It was the failure of the it was the failure of the wood along the sides of the HVAC unit that the HVAC unit was put into. It was the wood that failed.
Okay, thank you. Counsel, you have 2 minutes.
First, to counsel's Metropolis points that the accident occurred because of the condition of the wood. There's no party that offered that testimony. In fact, what plaintiffs themselves offered is that they saw and observed the roofing before the accident fell. They described it as solid. They described it as firm. They said that they didn't see any holes or defects. Plaintiffs themselves made that assertion about the quality of the wood on which they were standing. The second part is that the scaffold was not tied. Who was responsible for that? By the record, we could state that it was plaintiff's employees, Alabama.
That the scaffold was not what?
Tied.
How would that have helped here? The wheel went through the roof.
Because
so the fact that it was, whether it was tied or not tied, once the wheel goes through the roof, the whole scaffold is unbalanced.
Well, Judge, it was a matter of security. It was not secured. It was not secured.
A
They
tie
stated
would
that.
not have prevented the wheel from going down through the hole.
Well, Judge, respectfully, even though it may not have prevented the wheel from going down to the hole, we do not know what degree or what type of security the ties could have provided.
The issue is whether they were provided with a safe workplace to work on and to put a scaffold on. Isn't that the issue?
Yes, Judge, and to
Right.
that point, yes, Universal was responsible for the roofing, but the roofing wasn't the cause of the accident. The scaffold went into a hole created by another party. The size of that hole, the responsibility for inspecting the size of the hole, there's testimony that that responsibility was for Centrifugal, not Universal.
Even though the contract said that Universal had that responsibility.
The contract said that Universal had the responsibility of maintaining a safe roof environment. However, the degree
And where did this happen? On the roof.
it happened in a hole within the roof for which
On
Universal.
the roof.
Yes, Judge, but the responsibility for inspecting the conditions of that hole was not Universal. There's testimony plainly stated that it was Centrifugals. It literally says that Centrifugals was responsible for inspecting the hole, and they even mentioned to see if it was how big or how small it was. And then Wonderworks was responsible for covering. Thank you.
Thank you so much. No, that's it. Oh, one.
First of all, Your Honor, just real
Right.
quickly with regard to the issue of centrifugal, all of you, like I said, you can look to the terms of the contract. It's under the bid package schedule of values at page 2689 that says centrifugal had no responsibility with regard to protection of any of the work that it did. That's number one. Number two, counsel seems to think that Your Honors are not capable of looking at photographs and determining for yourselves whether or not this hole was created by something other than the plastic. Your Honors, you look at photographs all the time and make determinations of a matter of law, whether something is a trivial defect, open and obvious. There are cases in which Your Honors have looked at courts and photographic evidence and determined that a witness's testimony is incredible as a matter of law. So I find it somewhat unusual. I think that it's somewhat less than persuasive to state that simply because some other witness didn't look at a photograph and testify, oh, it's the failure of the wood, that somehow precludes Your Honors from using what we all have, common sense and common understanding, and looking at a photograph and determining for yourself whether or not, oh, look, there's a hole that goes 3 inches past the tape. It must have been something other than the blue skin membrane that failed. Thank you, Your Honors.
I didn't know if you were going to go, counsel. Thank you, Judge.
Thank you. Okay. Next case is JC and Infant versus London. I am recused from this case. Should there be a tie, the court will follow the appellate division rules in vouching in another judge.
Counsel, you may begin.
Good afternoon. May it please the court. Your Honors, this is a classic case of the lower court in this medical malpractice action overstepping its authority and engaging in improper fact finding instead of finding that there were issues of fact across the board with regard to all the defendants. Yes, Your Honor.
The expert affidavit that was submitted by you, how did it address the issue of, in 2015, the infant was asymptomatic, and then in 2020, symptomatic. In that time period, how did it address the issue of like whether or not a surgery should have been taken place, or?
So, Your Honor, the reason why the infant was referred to the pediatric neurologist in the first place and then ultimately sent for a brain MRI was because his symptoms were so bad at that time, between the headaches, the nighttime bedwetting, and this perpetual episodes of vomiting that was so severe that they sent him.
But the headaches were to the frontal portion, frontal lobe, right? Not to the occipital.
There were times where there was frontal headaches. There were times when there were back of the head headaches. That's really not the only finding that is, clear cut a Chiari malformation. But at the end of the day, Your Honor, what the defense in this case is basically saying is that it's pure speculation that just because they found this or that it was suspected in the MRI report, that doesn't matter. The kid continued on. He had some complaints. He was put on antipsychotic medication. He's put on imipramine, which is a urological medication. That is going to, yes, mask some of his symptoms, but that did not treat the root cause, which was known at the time when they sent him for the MRI.
So how do you treat this condition? Isn't it first with meds and then with surgery?
So it's first a waiting game. So you need to monitor this condition because it's a progressive condition. So the tonsils at the base of the skull will continue to move down and efface into the CSF fluid. So that will interrupt his neurological conditions. That will contribute to these all these symptoms, which when he presented to Dr. London initially and was referred to the pediatric neurologist, he had. And it was...
So, but at that time, when he presents to Dr. London at that time, he's complaining, according to the notes, he's complaining of frontal headaches. He's complaining of photophobia, phonophobia, vomiting. That's why he gets referred to the neurologist.
Correct.
Who says, okay, we'll treat him. And because the protocol should be first treat, and if the treatment doesn't work, then we look at surgery.
Right, but Your Honor, this is a neurological brain condition that warrants an evaluation by neurosurgery or some type of interventional surgeon that's actually going to look at this, see if the kid at that point was a candidate for surgery, which you can argue that he was. He was clearly symptomatic enough to present to this doctor and be sent for.
What are we to make of the fact, according to the records and the notes of these treating doctors, that his symptoms basically disappeared between 2017 and 20? He never came back, because when they last saw him, he had no more headaches.
Well, I think that there were definitely complaints of headaches. He had nausea. There was intermittent complaints of the bedwetting. Look, this condition is not the type that remains persistent. It can wax and wane, get worse and then better. But as the child was progressing during this time, there's no question that him and his family were under a completely different misconception of what was going on here.
Counsel, can you address the question between 2017 and 2019? Was there a gap in any type of symptomatology of frontal or back headaches? Did it just disappear from 2017 to 2019? Is there anything in the record that would support that there was progressive going on from 2015 to 17 to 19, then eventually to 2020?
Well, Your Honor, it's more of anecdotal. So when he presents to Boston Children's in, I believe it's 20...
I'm not asking for anecdotal. I'm asking for recordal.
No, I know what you're asking. In those records, he states in his history that he's had persistent headaches, that he's had nausea and vomiting for years at that point. So I understand what you're saying as far as a potential gap, but this is a family that moved from the Bronx, moved up to Boston. The kids still had these persistent symptoms. Reasonably, you're going to restart your workup, have to go to a new doctor who's then going to have to work this up. This is not an obvious condition. This takes careful examination and workup. But at the time in 2015, they had the diagnosis in front of them.
But when he got to Boston from 2017 to 2019, was there any documentation inside his medical records there of symptoms?
I believe in the intermittent records in between Boston Children's. But again, there was definitely complaints when he got to Boston Children's that this had been going on.
But is there anything documented? Anything documented?
Look, Your Honor, the record will speak for itself.
Okay. All right, thank you.
Yeah, thank you.
We'll have time on rebuttal.
Good afternoon, Your Honors. Greg Friedman for Dr. London and WestMed. You already asked a lot of great questions, kind of stole my thunder a bit here.
I just want to follow up on plaintiff's experts. Inside the affidavit, it says that the symptoms were progressive, or the malformations are progressive. So isn't that really addressing your expert's position and on this issue of proximate cause? And maybe don't proximate cause issues usually go to the jury?
No, I assume you're talking about Dr. London's and Westmed's expert, because we had an expert who addressed that, although the essence of his opinion was more to Dr. London's specific responsibilities as a general pediatrician. I believe it was the co-defendant's expert who really dove into the specifics, and I'm happy to speak about them. I think it's at 1364 to 1366 of the record, where, honestly, before we even get to this allegation, anything progressed, and it didn't. There's nothing in the record. There was certainly a sudden change in 2020, long after the child ceased treating.
When was the last time that Dr. London saw this child?
Dr. Lund, it was, I believe, 2016 for a routine checkup.
And so this is my point as to Dr. London. The plaintiff's expert says that he should have reached back out to maybe quarterbacked whatever treatment was going on there.
So I have a kind of twofold response at the first being the duty argument, because as I read it, we discussed it, I think, at 36 to 38 of our brief. To me, this is Bertman versus Brown all over again. The facts are virtually identical, where you have kind of a general care physician, a specialist who would order tests. The general care physician incidentally gets a copy of the test results, does not do anything with them. The specialist who had ordered them independently sees the results and decided, I don't see anything of concern here, we don't need to treat this. The trial court in that case made the same ruling the one here did, that, well, okay, the general care physician surely wasn't responsible for diagnosing anything, but she at least had to discuss it, right? There's an issue of fact there. Went up on appeal to this court, and this court said, no, the duty did not extend to that. There was already a specialist who was taking over this aspect of the care, knew the test results, and made her own determination as to what needed to be done. Therefore, the general physician could not be liable. Same exact thing here, and I'll just point out that we obviously discussed this a lot in our brief. Plaintiff doesn't even touch it in response. In fact, proximate cause duty doesn't address any of it. I'll just say this with respect to proximate cause. Our argument is that because Dr. Yozowitz, the specialist, was managing neurological care properly, Dr. London telling her, oh, hey, did you see this MRI report? It says there's a Chiari malformation, which no one even claimed he should have known what that was. Dr. Yozowitz already had her plan saying, I know what I'm doing. This does not require treatment. And the plaintiff, Ms. Carr, never said, she never testified to, never put an affidavit in saying, oh, if only Dr. London had told me, I would have done something different. She said, no. Dr. Yozowitz was the one caring for my son, and she called her up to ask about the MRI. So there's no duty, there's no proximate cause. I don't know if you want to hear about the qualifications argument. We usually don't even make it, because I know it's usually a question of weight.
What complaints did the child have the last time he saw Dr. London?
The very last time he saw him, I think, and again, I'm sort of going off the top of my head for that specific visit, but the headaches were largely resolved. They were managed by Lexapro, and the conditions, the complaints that the child did have were completely unrelated to this. And the fact is, the child saw Dr. London not for his neurological care, since he'd already been referred to a specialist, but for whatever else a pediatrician might see him for. And I assume that co-defendant will get to the substantive merits of the malpractice claim, but the key point is the experts listed, I think, no fewer than 8 signs of a symptomatic Chiari, but the most important one are these occipital headaches, and not just that they're in the back of the head. It's that they're sharp, they're short-lived, they're brought on by certain types of exertion. You've seen the records. The child did not have any of it, no matter how much plaintiff wants to claim otherwise, and his expert didn't even use the word in his affirmation, so I don't see, under the case law, how we ever raise an issue of fact.
Are you referring to tussive occipitable headaches? Is that what you're referring to?
Is it tussive?
I don't know how to pronounce it. Maybe I'm saying.
I was thinking of Robitussin, and I know they're completely unrelated, but...
I said tussin.
That's how it sounded, yes.
Yeah.
Counsel, you have time on rebuttal.
Thank you very much.
Tussive. I don't know either.
Who knows?
Good afternoon. May it please the court. Jacob Bentley for Dr. Yozowitz, Dr. Burns, and Montefiore Medical Center. So first I would like to focus on Dr. Burns. Plaintiff's expert was unable to raise a triable issue of fact as to Dr. Burns because plaintiff's expert, as a neurosurgeon, did not have the training, qualifications, or expertise to opine on the standard of care of radiology. As this court knows,
Well, he says that because the initial MRI was kind of blurry, he should have done a repeat MRI.
well, Your Honor, so in this case, it's about whether Dr. Burns deviated from the applicable standard of care. The applicable standard of care here is radiology. Plaintiff's expert has professed no expertise in radiology specifically. Sure, he or she has stated they've interpreted MRIs. They're no doubt familiar with them, but they don't know specifically what the standard of care for radiology requires. Therefore, they cannot opine on it. And
Counsel, doesn't that go to weight, as counsel just alluded to earlier, whether or not that is the case? Because I understand a radiologist is a professional in that field, but this is a professional that's been reading it for decades, and he believes it should be repeat. Wouldn't that be, at least for the trier of fact, a weight issue?
Well, Your Honor, this court's case law has decided cases when there's an expert opining outside of their area of expertise and did not provide.
Very rare for this court to say that, and that's why that argument's not raised. Just, I've been on a number of appeals, and I think we've rejected it almost every time in the last several months. So can we move on to the
Yes,
substance?
and I would say the Chiari malformation was diagnosed in Dr. Burns's interpretation. He diagnosed it. He put it in the report. He sent that report to Dr. Yozowitz. Plaintiff's expert is saying that he should have himself rescheduled a second MRI. He should have talked to the parents himself. He should have talked to Dr.
Why isn't it departure for not doing a repeat when the MRI was not sufficient because of it was blurry? I used a certain word. I don't remember the exact language.
A motion artifact, I believe.
Correct.
Yes. Well, the condition was diagnosed in this MRI, and then once Dr. Yozowitz has that information, Dr. Burns's job is essentially done. It is Dr. Yozowitz's job to reschedule one if needed. Dr. Burns, as a radiologist, he takes the MRI, he interprets it, he puts it in a report, and he sends it to the treating physician. That's exactly what occurred here. So there's no deviation, and we can move on to causation, but we can also just talk about Dr. Yozowitz and Montefiore Medical Center in general. And once again, there's a failure to raise tribal issues of fact here because plaintiff's expert does not address and certainly doesn't rebut various key points of defendant's expert's affirmation. We discussed the occipital headaches. As co-defendant was saying, it's not just that they're in the back of the head, but also they're very sharp. They can be quick. They're not, they don't respond to medication. Here, during the time, the relevant time, plaintiff, his headaches were front, they were migraines, they lasted a long time, they responded to treatment.
Counsel, you're arguing there's not been any evidence in the record of any headaches on the base of the brain, towards the back of the head from 2015 through 2017, only in 2020, that's when you had the occipital headaches?
In fact, the infant plaintiff testified in his deposition in 2020, the headaches became, quote, definitely different. This was a different type of headache. It was the Chiari becoming symptomatic.
But did plaintiff's expert somehow allude that these symptoms are progressive in nature, and it would have taken maybe a certain amount of time for them to reveal?
Yes, he said it was progressive, but plaintiff's expert still did not address the specific underlying reasonings behind defendant's expert, Dr. Wissov's opinion, the fact that specifically that it responded to treatment, and if this was or medication rather, and if this was a Chiari, symptomatic Chiari, that response would not have occurred. Plaintiff's expert never addressed that specifically. It was a saying.
So counsel, let me read you paragraph 108 of the plaintiff's expert's affidavit on 3462, because he really doesn't say that. He says something very different, and I think this is important. This leads to, he's referring to the non-diagnosis and the amount of symptomatology that led up to this. This led to years of significant and permanent harm, including what would ultimately be a far more substantial surgical course consisting of 2 major decompression surgeries and 1 untethering of the spinal cord. What he's arguing is that because of the lack of diagnosis, the harm was greater in 2020. And I didn't see anything in defendants' papers which would negate that finding.
Well, Your Honor, his symptoms were being treated with medication, and
Can
both.
you answer my question? Did anyone address that it was basically he was saying because it wasn't diagnosed in 2015, in 2020 it was a much more severe operation. Was that addressed?
Dr. Wissoff stated that both experts agreed that a surgery is not indicated until these occipital headaches arise, until it becomes symptomatic, and that did not occur until 2020. So even if everything plaintiff had requested to be done was done, nothing would have changed in the long run. That was Dr. Wissoff's final point.
So there was no need for surgery up until he started having those headaches in the occipital region.
Correct.
Thank you.
Thank you, Your Honor.
Rebuttal.
Excuse me. Your Honors, with regard to the need for surgery, we don't know during the intermittent time between 2015 when he was diagnosed via MRI reading of a suspected Chiari malformation, which was never confirmed, and most importantly, never measured. The measurement aspect of this condition by a radiologist is paramount for treating this condition so you can monitor the progression of the tonsils going down into the spinal canal, which at the point when he was at Boston Children's was about 12 centimeters. I believe it was something around 9 when they...
Counsel, could you address the argument, which I think is the an issue in the case, is that it was not the condition of the plaintiff was asymptomatic until 2020, and therefore the conclusion drawn by defendants' experts is that you had to wait anyhow until 2020 to do the surgery, therefore no harm, no foul. That's essentially the argument. How do you address that argument?
It's essentially ridiculous, Your Honor. First
Why is it ridiculous?
Because his symptoms were so severe in 2015 that he warranted this workup which found this condition where he could have been a candidate at
Plaintiff's
that time.
doctor testified that the surgery was necessary in 2015, and it wasn't the onset of symptomatology in 2020 that caused a new surgeries to be conducted by the doctors.
Your Honor, he couldn't have testified to that as a reasonably a good opining physician, a neurosurgeon, because you have an MRI that was so bad, the artifact was so bad, you couldn't make a full diagnosis of what actually was going on. You could see that it was a suspected Chiari, but that goes right back to
saying no one could tell because the MRI was so bad.
That's why the artifact was so bad. That's why it was required to bring the kid back, do another MRI, and at least talk to the parents at the time. And there's one point, Your Honors, before I get out of here, is...
Before you do that, Justice Higgins has a question.
Could you walk me through your expert's proximate cause syllogism?
Sure. There's essentially 2 parts. You have the extent of the surgery, the ultimate decompression, the brain surgery this child had to undergo was more significant, leading to a much more the need for a more significant surgery, which is in his affirmation, as well as the potential for needing additional surgery, which the kid ultimately did need. It also progressed with the tethered cord because when the tonsils get to a certain point, it essentially cuts off the CSF fluid within the spine, and what happens is the cord sticks to the side of the spine. So he definitely didn't have that in 2015. The lumbar MRI was normal, and that had to be addressed surgically as well.
Did the plaintiff's expert say anything about, well, had this been caught in 2017, it would have been measured here, and then surgery would have been needed to be in a surgical intervention at that point, or 2018, he wasn't being treated anymore. But, or does he just say, had it been caught sooner, surgery would have been needed?
Your Honor, it comes down to a failure to appropriately diagnose and treat this condition, which requires maintenance, which requires surveillance, to watch the condition, to see how it grows with the child's symptoms. That you don't want, the last thing you want to do is mask with Lexapro and imipramine, so you don't know what his true symptoms are.
But he stopped treating with Dr. Yasowitz and Dr. London in 2017. They didn't see him again until he complained in 2020.
Because Dr. Yazowitz and her PA in the notes told him everything is normal. Why go back to a
Because he had no headaches at
No,
that
no,
point.
no. Your Honor, respectfully, they told him it was normal based on the MRI. What's said in the note, excuse me, on 128, Yazowitz's note is that the MRI results are normal. So why would they think?
What year?
I'm sorry, it's in 2015.
2015.
This is 3 days after the MRI.
Okay, thank you.
Thank you.
Thank you.
You have 1 minute, Counsel.
I have 1 minute. I'll try to make the most of it. Justice Hagler, you all hit the nail on the head when you're asking about symptomatic versus asymptomatic TRs. It's not just symptoms in general. I don't think anybody's doubting that in some form or another, the child had issues with his head, whatever it might be. But there are very specific symptoms that suggest a symptomatic TR. He did not have them. And this was kind of the linchpin of the defense experts' opinions as far as the malpractice claims went. And I don't have to cite them. There are a million cases saying that a plaintiff's expert has to specifically address all the assertions of the defense expert.
Are you saying that the lack of occipital headaches is a major factor in there being no proximate cause of the 2020 surgery?
It's proximate cause, and also even before then goes to departure because...
Saying there's not even a departure.
Correct, because without specific clinical signs to arouse suspicion for a symptomatic Chiari, there is nothing to treat. And I know my time is up. I'll just politely ask you to take one more look at Bertman versus Brown and its Markley versus Albany Medical Center. It speaks to the exact duty argument that we have here for Dr. London. Thank you.
Thank you.
Thank you.
You have 1 minute, Counselor.
Yes, Your Honor. So plaintiff's expert's causation opinion that this Chiari was allowed to progress and got worse, and as a result, the 2020 surgery was worse, is purely just a conclusory opinion, because there's nothing in it, as Your Honor's asked, saying that had it been caught in 2017, the surgery would have been like this. Plaintiff did not have the Chiari's symptoms. He didn't have the occipital headaches. His headaches were treated with medication. There's nothing in, both experts agree that intervention, especially surgical.
Counsel, why isn't there at least an inference? If in 2015, Dr. Yasowitz says it's suspected, and then you see it in 2020, why is that conclusory? Why can't we make the logical conclusion that if it was suspected in 2015, that it carried over into 2020?
So the issue is whether it was symptomatic in 2015.
Why does it have to be symptomatic?
Because that's when both experts, plaintiffs and defendants, agree that's when intervention is necessary.
How do you deal with the argument that it has to be maintained, surveilled, and he was suffering for 5 years for this period of time without it being addressed? And that's what the plaintiff's expert says all over. I could read you paragraph after paragraph.
Correct. So what Dr. Wissoff, our expert, was stating is that these were the issues the infant plaintiff had, these migraine headaches, this bedwetting, were from different medical maladies outside of the Chiari because the symptoms don't match. Therefore, the treatment provided to the infant plaintiff was within the standard of care and did not proximately cause any injuries.
Thank you, Counsel.
Thank you.
Thank you all.
Thank you.
Hudson, ES LLC versus First Frank Financial.
Good afternoon. My name is David Kleban for the appellant, Hudson ES.
There are two pathways for reversal here. One is for this court to take a harder look at whether a stranger to a trust instrument can invoke its no action clause. I'd like to spend more time on the second pathway, which is that even if this court does award First Franklin the benefit of invoking the no action clause, compliance with that clause is not required under the circumstances in this case. The trustees and First Franklin's conduct could not have been better designed to frustrate the compliance with the no action clause and the assertion of timely claims here. In 2012, the trustee, at the direction of certain holders, entered into a tolling agreement with First Franklin, but it accepted First Franklin's demand to keep that tolling agreement secret, even from the trust's beneficiaries. It did so for 6 years, and in the meantime, First Franklin went out and it bought up certificates and took control of a large swath of the voting interest in the trust. We don't know how much, but we know that this was their MO, because every time a case has gone to litigation and discovery has happened, we find out that First Franklin and its affiliates have bought up massive swaths of trust to which it bears.
Basically, they did this to prevent anyone from having the required percentage in order to have the trustee litigate?
Exactly right, Your Honor. That is the claim in our complaint, our amended complaint that was dismissed by the lower court. Now, the trustee did finally get around to telling certificate holders that there was this tolling agreement preserving the claims, but it only did so after First Franklin said it could. And by that time, there was only 57 days left until the expiration of the tolling agreement. That made it literally impossible for anybody to comply with the no action clause's 60-day notice requirement without imperiling these claims and risking that they would be time barred. It was an ingenious and devious move by First Franklin. Meanwhile, the First Franklin bond purchases, which our complaint, I believe, entitles us to discovery about, made it functionally impossible, as Your Honor observed, for anyone to gather a coalition of people with at least 25% of voting rights. Hudson, after seeing this belated notice with 57 days left on the clock, approached the trustee, offered what we allege is a reasonable direction, simply to file a summons with notice. Preserve these claims, give us more time, and we will indemnify you against the costs of doing so, against the liabilities you will incur by doing so, to the extent that you are unable to retrieve that indemnity from the trust. Now, this is a extremely simple act, and it would have resulted in the preservation of a $1 billion claim, yet the trustee didn't do it. It didn't follow a direction and indemnity that we say is reasonable, and that put it in violation of Section 8 of the PSA, 8.02A9, which is at page 194 to 195 of the record. So the sum of this is that the trustee irrationally and unreasonably declined to preserve the trust claims from the emergency situation that it and First Franklin together had created. This court and others has recognized that these circumstances forgive compliance with a no action clause because the Court of Appeals in the IKB case that we cite, IKB International versus Wells Fargo, says that when the trustee's conflicts or irrationality bar the no action clause path to relief, it forgives compliance with the no action clause. Even the Feldbaum case, which we are no great fans of, recognizes this too. It says that compliance with a no action clause is excused if the trustee has breached its duty under the trust indenture. And this court, similarly, in the matter of Part 60 decision, the no action clause's limitations don't apply if the trustee abdicates its function.
Could you address your friend's argument that you failed to meet the pleading requirements for a derivative action?
Yeah,
specifically the contemporaneous ownership requirement?
there is no contemporaneous ownership requirement for a derivative suit brought pursuant to a bond indenture. This is not a suit, derivative suit in the corporate context in which there is a specific statute on point in the corporation's law. This is a suit basically under the common law principle that beneficiaries of a trust can bring derivative suits if the trustee fails to do so. And the legislature has not elected to impose a contemporaneous ownership requirement. And the one case, the SC note case, I think a district court case, that has applied a contemporaneous ownership requirement in a bond context, in an indenture context, did not explain its reasoning for taking a rule from one context and grafting it on to this one. And in fact, we have evidence from the legislature that it does not intend to impose contemporaneous ownership requirements in the bond indenture context, because we have General Obligations Law 13-107-1, which says that the purchaser of a bond, the transferee of a bond, takes with the bond all of the claims, all of the rights that the former owner had. So if this court were to break new ground and apply a contemporaneous ownership requirement in this context, it would be quite dramatic in that regard. Thank you.
Good afternoon, Your Honors. Elaine Golan for First Franklin Financial Court.
Counsel, does First Franklin have standing to object to plaintiff's lawsuit against the trustee?
It's not a lawsuit against the trustee. It's a lawsuit against First Franklin. So the question is, do we have a right to defend ourselves in a lawsuit against us? And under this court's opinion in Freedom Trust from 2023, which is squarely on point, and my colleague would acknowledge it's squarely on point, we get to invoke the no action clause to mandate the dismissal of this suit against First Franklin, because as Mr. Cleveland would acknowledge, they did not comply with the no action clause. That's in their papers. They don't dispute that the First Freedom decision from 2023 is squarely on point. What they're asking you to do is reverse First Freedom, even though this court decided it only 3 years ago, even though the Court of Appeals denied leave to appeal in that case, indicating that they didn't think this court got it wrong, and even though, as we all know, stare decisis is a very important principle.
So the argument of futility that your adversary is putting forth as to why they didn't need to comply with this no action clause, how do we look at that?
Well, let's talk about...
Particularly in light of, I think he referenced the IKB case.
Sure, so we can talk about IKB. IKB is a suit, involved a suit against a trustee. And IKB says it's futile. If you're asking the trustee to sue itself, that would be futile. That is the type of conflict that excuses compliance with the no action clause. Because if you're coming in and saying, trustee, I want you to sue yourself, no trustee is going to do that, it's futile. Here what we have is a lot of speculation and frankly things that are not in the record. He says we bought swaths of certificate holders. That's nowhere in the record. That is literally nowhere in the record. He has no information about whether my client owns a single certificate. He's just alleging because he's seen in some other cases there were certificates bought. There's actually never been an allegation that we acquired so many certificates in any trust that we prevented someone from amassing 25%. So he's just making this up out of whole cloth. And under the cases we cited, page 23 in our brief, speculation does not get you that far. As far as the futility of the 57 days, again, that's fictitious. He didn't even argue, he didn't even brief it below because it was a very last-ditch argument. The no action clause says that you have to do a bunch of things. You have to allege an event of default. You have to offer the trustee a satisfactory indemnity. You have to amass 25%. And then you have to give the trustee notice that you've done all those things. And then the 60 days comes into call.
Did the plaintiff allege an event of default?
No, the plaintiff never alleged an event of default. And under Walnut Place, you clearly have to allege an event of default. That's the way the no action clause works. And finally, I want to say the other piece of speculation was that there was a plot. He said something like this devious move by First Franklin and trustee. Again, that's not in the record at all. There's no record that First Franklin was manipulating or pulling the trustee's strings at all. And frankly, that's the first time I've heard this out of
That's
their mouth.
with respect to the tolling provision?
Sorry?
With respect to the tolling?
Yes, you're right. The trustee entered into tolling for 6 years, preserved the trust claims for a maximum of 6 years, and as trustee did in other circumstances, the trustee then put out a notice to certificate holders. This was standard practice in RMBS as we got to the end of the 12-year period. The trustee put out a notice to certificate holders, said, I need a direction and indemnity if you want me to pursue litigation. Sometimes certificate holders came forward. In this case, only Hudson came forward, and Hudson provided an admittedly unsatisfactory direction and indemnity to the trustee. He said, you can get the indemnity if you can't get it from the trust. Well, having to look to the trust assets is not a true indemnity. So we just never get to this point of futility because Hudson never did any of the things that it needed to do.
Thank you. You have 2 minutes.
Thank you, Your Honor. So there are, I guess, two things going on here. One is that the trustee breached an obligation to follow a reasonable and adequate demand that it take action to preserve these billion-dollar claims. It didn't do that, and that freed Hudson to act in its stead. The other is the futility argument, which is not based on speculation, but on facts that are pleaded in the complaint. We're at the pleading stage. We get the benefit of every reasonable inference. And if First Franklin does this, if First Franklin and its affiliates do this in every single case in which we find out about its holdings, then it's a fair inference that they did so here.
Sir, what was the event of default?
There is no allegation of event of default, Judge, and that brings me to the other point. When one aspect of a no-action clause is futile to comply with, the whole of the no-action clause is excused. That's the IKB case from the Court of Appeals and the BlackRock decision from this court in which the court said once performance of the demand requirement in the no-action clause is excused, performance of the entire provision is excused. The idea is not to impose some Protestant work ethic that you fulfill everything you can, and if you get close enough, then we forgive. The point is, if it's futile, it's futile, and it was rendered futile here by the trustee itself and by First Franklin under the well-pleaded allegations. The 57 days, it's clear on the face of the record. I argued it to the trial court. The fact that we didn't put it in the brief is not a reason to affirm where it is clear that the trustee made it impossible to comply with the no-action clause here. Thank you.
Thank you. $350 East Houston Street versus Travelers Indemnity.
Good afternoon, Your Honor.
Good afternoon.
May it please the court. My name is George Maniatis from the law firm of Weber Gallagher, and we represent Appellant 350 East Houston Street. And this is an appeal from the decision of the trial court, and there's 3 rulings that we are appealing. The first one is we believe that the court should have granted the 350 East Houston full contractual indemnity against cops under the trade contract entered into between Noble, who was the construction manager, and Cops, who was the drilling contractor. What the court below did was they found that there was indemnification within the broad language of the indemnification provision. It's an arising out of trigger, so it was very broad. And then they said that 350 was not directly liable for the loss. So far, so good. But then the court went on to award conditional contractual indemnity, and that was based solely on the affidavit of a former construction manager supervisor, Mr. Keith Francis, who prepared an affidavit, and basically his affidavit stated that the day before the incident took place where the building shifted, there was a meeting, and that 350 East Houston Street refused to approve change orders regarding subsurface conditions and directed Cops and Peterson, who was their drilling subcontractor, to continue work. Just for information, the drilling had started back in December, and the incident took place in March. So drilling had been proceeding for 4 months. This meeting took place, less than 24 hours before the shifting of the building. So it's hard to see how that's a direct cause of the loss. But importantly, that
Why? Why?
I'm going to say, in the trade contract, there's an alternative number 7, which is key to this case, that 350 East Houston.
You're not responding to my question of why.
What?
You said that it's hard to see how the day before the shifting would have occurred. Why?
Why? Because drilling had been ongoing for 4
So
months.
what?
So it's hard to see
It
how.
depends on when you reach the bad point is when the shift happens. So it happened the day before. How do I?
Well, the meeting happened the day before. The shifting happened the next day. And the reason that 350 East Houston.
You're making a conclusion based on that timing, and I'm not sure what the evidentiary foundation for that conclusion
Well,
is.
the evidentiary foundation is
That it doesn't make sense?
Sure. Cops put in an expert report, and they blamed Peterson for the cause of the loss. Peterson put in an expert affidavit, and they blamed the geotechnical engineer. No expert blamed 350 East Houston for the cause of this loss.
No, the question was, if you're told we have a problem with the shifting of the ground and the rock doesn't seem stable enough, that's what they were saying, that they should stop and that additional.
It's not a question that they should.
Counsel, when I'm still talking, you should not be. Just a general rule, okay? I find it really, really difficult to understand why that evidence we should be reaching a conclusion based on that.
Okay. In the trade contract, Cops specifically agreed to assume the risk and responsibility for all unforeseen subsurface conditions. So it was understood by all parties that if there was any additional action that had to be taken with respect to the unforeseen subsurface conditions, any change orders would be the responsibility of Cops and Peterson.
They had to be approved, no? I mean,
When you say approved, it was on, I think the owner took the position that it was Cops' responsibility to undertake whatever needed to be done with respect to
again, but if the project costs were $600,000 to shore up the building and make sure that our neighbor's building is safe, and in the middle of the work, they find soil conditions, rock conditions that are unstable and say to the owner, we need to go further because this isn't safe, Cops can't authorize that new expenditure, can they? Without the owner's okay? Because it's a change order, right?
It's something 350 paid $50,000 for Cops to assume financial responsibility to.
Oh, so if $3 million worth of additional work, let me finish, if $3 million worth of additional work was needed for the $50,000 they got extra, you were covered then? That's your argument?
Well, yes, Your Honor. I mean,
All
the reason
right.
is, well, wait a minute.
I can't believe that that's your argument,
Well,
but I got it.
Well, because you got to remember there were geotechnical studies, and Cops and Peterson were free to undertake their own geotechnical studies to map the subsurface conditions. Okay. And that's what a lot of times was it worth the $50,000?
Counsel, you're past the light. You'll have time on rebuttal. Oh, you didn't reserve time on rebuttal. Thank you for your argument. Next.
Good afternoon. My name is
How
Evie.
much time did you have? There's a bunch of you, so I'm trying to
I
keep
said
track
5
who
and
asked
2.
for
I
what.
actually this time said 5 and 2.
5 and 2, okay.
So I represent cops.
Go ahead.
And I'm going to jump right in with respect to the issue of the shifting with respect to the work. COPS was retained in November of 2016. The work started in December of 2016, and this shifting, the stop work order, where the adjacent, they started in March of 2017. However, at the record at 967, Peterson, in February of 2017, sent a letter starting to say that the micropiling was at issue. So already back in February of 2017, there was already notice to the owners and Noble. But I want to take a step back. COPS had, there were 3 motions that COPS is here for. So motion sequence 7, 8, and 10. Very quickly. They all involve the indemnification clauses and the work that's done. COPS was retained like a typical work site, and then they filtered it down to Peterson. So COPS' argument in the first instance is that there's no actual negligence, which is the 7th cause of action. They filtered it down to Peterson. That's evident by these letters and the fact that Peterson was doing the physical work. With respect to the indemnification clause that we're talking about, that's 12.2. There are 7 other indemnification clauses, or 6. Why that's important is because the contract was between Noble and COPS. And with respect to Noble, it all becomes together, is that we third-partied in Noble. Noble for common law indemnification, contribution, they have a bare bones contractual backup. Noble is saying this is a completely economic situation. The problem is that we have the owner of the physical property that was being built and the adjacent property. A lot of times here, I think I've been before this court, it's usually just the adjacent property, it's a tangible property, issues with how they shift and what they do. So the fact of the matter is here, we have 5 different decisions. The 3 that I'm talking about, the judge makes different types of facts of law across the 3 different decisions. So that first we have decision 7 where 350 was granted conditional indemnification. I agree that there are issues of fact clearly about what 350 Houston knew. They are sophisticated owners. They were involved. They stopped the work. They paid for the work. These change orders in the field of construction, we don't do work unless you're going to pay us, and you only agreed to the work. This is clearly in this case. Peterson was already telling 350 and Noble that there were issues with the micropiling because they hit the bedrock on that site. Then in March, the adjacent property, which is an 80-year-old property and has its own damages issues. So with respect to the indemnification clause, it says caused by, arising out of, or ellipses with respect to the contractor or subcontractor. The judge found that Peterson's, it's a question of fact as to what they did. So overall, what we have here is a hybrid situation of possible economic situation with respect to the stop work, how much delays, and then you have also the tangible property. So with respect to Noble, the third-party action should not have been dismissed. And with respect to Noble, the contractual indemnification should not have been granted because there are at least 3 clauses that carve out indemnification, the lack of indemnification as to the negligence of the construction manager. This record is 1,500, it's large, so that when you extract it all very briefly, as I'm trying to say very quickly in my time, is that you have a site being built, the adjacent properties alleging it's slipping. We're there for 3 months, meaning COPS/Peterson. So also wrapped up in all of this is what are the damages for those 3 months, possibly the stop work for that time. But then the stop work went on for 8 more months. And then 350, rather than have a subrogation action, decided to pay for the damages themselves. So they paid whatever the adjacent landowner said. So there's also that secondary issue of damages, which in these kind of cases, as the court knows, it's all mixed up with the indemnification vis-a-vis the damages. So it's not a simple personal injury, scaffold case that falls through a blue sheet. So that the judge was wrong on sequence 7. We should not have been, 350 should not have been granted summary judgment as to the indemnification at all. They clearly had their own issues, as the court already noticed. Cops should have been granted on the 7th cause of action. They had no actual negligence. And vis-a-vis Noble clearly, even though they say they're a construction manager and had nothing to do with anything, the contracts are all in their name. There are at least 3 different indemnification clauses within the cops contract that carve out their own negligence, and we don't have to pay for them. And
You're for cops, correct?
for cops.
Yes. Was there something from a former engineer that said cops had direct supervision over Peterson and they had to be on site for Peterson's work?
So to the extent that cops had quote unquote site supervision, they were the ones that were retained and they stayed on site because they were an out of country. They were a Canadian company that sat there. So it's similar to any construction situation. They were there to be the go-between because Peterson was the subcontractor. But the letter was written by Peterson directly to the owners and everybody else. And that cops did not provide that particular work. We're talking about the micropiling between December of 2016 to March of 2017. Cops may have done other pre-work, and both of them left in March of 2017. So that cops was there. Cops was part of the conversations like everybody else, but the actual physical work was clearly done by Peterson. Thank you.
You have 4 minutes, correct?
Yes, Your Honor. Good afternoon, Your Honors. May it please the court, Edward Benson for Temple Insurance Company. Insurance companies do not generally say ignorance is bliss. Their policies require prompt notice of occurrences and claims so that they can investigate, decide on coverage, and have a say in any remediation work. Here, 350 East Houston knew that notice was required to Temple.
They did. Did they send out notice letter? Did they notify Temple that they were making a claim?
Yes, Your Honor. So what happened was a letter was sent to a number of different parties. As a carbon copy, there was an address for Temple, but it was an address in California. They mailed a letter. We know that it was to California because it came back undelivered. It's in their file. They also have in their materials a FedEx label, but that's all it is. It's a label. There's no evidence that it was a label placed on a letter. There's no evidence it was delivered to FedEx. In fact, quite to the contrary. We made inquiry. We used the tracking number, which is a common approach. Is there any confirmation of delivery? No.
Does Temple, in addition to what you're stating, maybe an issue with the notice, do you have to actually show prejudice? And did you show prejudice?
Yes, Your Honor. So the trial court found prejudice based on an irrebuttable provision in the insurance law, 3420C2B. And that provision says that where an insured has resolved the claim by settlement or other compromise, there will be an irrebuttable presumption if notice was not received before then. That's the basis that the trial court found. It's something we briefed before this court, and I think it's telling that my adversary did not respond to that. It seems like an ostrich type of defense. You bury your head in the sand with a view to perhaps the court won't recognize it. But yes, Your Honor, we have that irrebuttable presumption of prejudice, but quite frankly, even if we didn't have it, you have a situation here where for 11 months, work was carried out at the site. Temple Insurance Company had no opportunity to investigate, no way to question any costs. They were effectively, on receipt of this lawsuit, presented with a bill of goods and told, pay up. And that's not how the system is supposed to operate.
Is that the first time Temple learned about this matter when it received the lawsuit?
That's correct, Your Honor. And you can imagine they were somewhat perturbed by that.
Indeed.
Thank you.
Good afternoon, Your Honors. Christopher Kratchmer on behalf of Noble Construction Group, respectfully requesting permission to argue despite being late for the calendar call.
Whenever you are running late, you should call the clerk's office, because then when you get to the court, you don't get bitten at.
I will do that in the future. As soon as I realized I was at the wrong.
So I'm going to give you 4 minutes, but please
Thank you.
call the clerk's office if you're running late.
Thank you, Your Honor. I appreciate
You may
that.
proceed.
The Supreme Court's ruling granting contractual indemnification to Noble against cops should not be reversed because, first of all, there's no showing of any kind of active negligence by Noble with respect to the property damage issue. Noble did not supervise or control that work. Rather, that work was performed by Cops' subcontractor under Cops' supervision. In fact, per the trade contract between Cops and Noble, Cops was expressly obligated to provide supervision for all that work, and that work was within the scope of work identified in that contract to be performed by Cops. Furthermore, Peterson's principal testified that he reported to Cops regarding that work throughout the duration of the work, and that he wasn't even allowed to perform drilling work on the project unless Cops was on site. Noble's role on this project was one of a construction manager. It was limited to administrative oversight, coordinating communications between trades and the owner, and monitoring that the project was proceeding in accordance to plan and complying with the
Did Noble also have to approve any change of conditions and alternative micropiling procedures?
I believe they would have passed that on to the owner and the engineers, and the owners and engineers would have had to approve those changes.
Am I correct that there's evidence in the record that Noble was at least partially responsible for the decision to reject the Petersons and Cobb's recommended changes?
Noble's role in this project was limited to passing the RFIs and communications from the trades on to the owner, and then operating under the owner's instructions.
The question was whether he recommended rejecting the recommendations by Cobb's and Peterson, because he's on site. He's the one who sees. He's the one who knows. The owner's not going to know what's happening in terms of the pilings or whatever. Your construction manager who's on site and sees what's going on, I would imagine, why hire someone if you're not going to ask for their advice? And did they give the advice to reject the proposed changes of Cobb's and Peterson?
I do not believe that they did give that advice to the owner. And even if it were accepted that they rejected the changes proposed by Peterson, that isn't enough under the Court of Appeals decision in McCarthy and Turner, which requires actual supervision and direction of the work being performed, which was just.
Well, I mean, if you're rejecting what the contractor is suggesting needs to happen for safety purposes, and then the entire work site gets stopped for 8 months because of it, seems to me that's an issue of fact, no?
I would say under the law, under McCarthy v. Turner, it does not constitute the type of actual authority and actual supervision required to have a finding of active negligence.
All right, thank you. You have anything else? You still have 36 seconds. They're all yours.
As to the nature of the economic loss claim, actually the Court of Appeals recently addressed this in 2018 in a case where it was alleged that a neighboring property experienced settlement issues, and they dismissed the tort claims as duplicative of the contractual claims, reasoning that they were not the type of abrupt damages that would necessitate a tort claim. Rather, they were the type of damages that had been within the contemplation of the parties during the process of negotiating the contracts.
I believe that's it, right?
May it please the court,
Abe Reichik from Katz and Reichik, representing the defendant, respondent, Peterson Geotechnical. I'm only here to address that portion of the appeal regarding the potential preclusion of the expert affidavit of Dr. Toman. The lower court properly considered whether that CPLR 3101 D1 response was appropriate. There's no reason for this court to supplant its determination as to the lower court's decision. There was no prejudice. The order was for the disclosures to be submitted by September 22nd, 2023. It was submitted by September 22nd, 2023. In a subsequent period of time, there were affidavits. There was a motion for summary judgment. There was a lot of detail in that, and the expert by Peterson properly opined on that determination and provided further detail. It complied with 3101. There's no reason why the expert affidavit should be precluded, and respectfully request that that appeal be denied.
You have 2 minutes.
So very quickly, with respect to McCarthy v. Turner, that's just with common law indemnification. We're talking about actual negligence, and the actual negligence is that they're on site and that they are also running the site, not that they're actually supervising and controlling Peterson, which is not the true issue here. We're talking about the contribution claim even more so than the common law indemnification claim. Their own client, Izzo, testified that they were there, they were talking to people, they would do the RFIs, they would run the contracts and things of that nature. With respect to this issue of economic claims, it's clearly hybrid. There are issues within the contract that they would be responsible for their own negligence in 7.12, I think 11.g, we point them out in our brief. So that obviously there's a contemplation that they could, meaning Noble, could do things negligently, not about supervision and control. And then there's this whole thing about the stop order and the damages per se. With respect, I just wanted to bring up, which I just realized, 350 is not seeking to overturn that portion of the decision that Peterson, there's a question of fact as to Peterson's work. So if COPS didn't physically do the work and Peterson has a question of fact, right now that indemnification clause 12.2b should be a question of fact in totality. Thank you.
Have a good day, all. I just get 1 minute. No, you didn't reserve any additional time. People v. Jesse Joku. You asked for 5 minutes.
Thank you, Your Honor. Good afternoon, and may it please the court. Cara Lubini for the Center for Appellate Litigation for Mr. Jesse Joku. Mr. Joku received no meaningful representation here where his lawyer failed to learn which alternative pleas could have averted the consequence of mandatory deportation.
Alternative counsel. He slashed somebody in the face and they have 25 stitches.
Yes, Your Honor.
There is no reduction that would have avoided immigration consequences here other than a misdemeanor.
No.
And there was no way they were going to get a misdemeanor on this case.
I'm glad you asked that because that seemed to be the position of the defense counsel, but that is not the case. The alternative consequences, the alternative plea deals was a C violent, he pled to a B, a C violent with a sentence the same or higher than the one that he actually received. There were two lawful plea alternatives that we put forward.
A C violent avoids immigration?
Two particular C violence, yes, avoids the consequence of mandatory deportation, which creates a permanent bar.
Violent slash to somebody's face. That is, I don't know.
The C violent coming with a 4-year sentence, because it was a 1-year reduction, if I'm understanding your position correctly.
So the two C violence that were available, and I'd like to also address Justice Mansonet's question about the severity of the crime, but as to your question, Justice Pitt, the C violence that were available, he could have pled to the C violence that were available with the same sentence that he received, 5 years, or even a higher sentence, 6+. in order to ameliorate
Counsel,
the consequences.
Wasn't it true that those were reckless and felonious rather than the intentional crime that was actually admitted to? How would you do reckless when this wasn't a reckless type of situation? That was the problem with the two alternatives.
Sure. So backing up and also looking at the consequence and bringing in Justice Manzanet's concerns. The chief assistant at the time of the plea testified at the hearing that the office's guiding principle was whether deportation was warranted in a particular situation. If it was not, the office would have extended, she said, would have done basically anything, would have extended an offer as long as it was lawful. In order to come to the decision of whether deportation was warranted, and I'll remind the court that this is a 23-year-old defendant who has been in this country since he was 6 years old. It's his first felony offense, who has suffered unimaginable trauma at the hands of his extremely sadistic father. It is difficult to imagine.
Does he have any other felony convictions other than this conviction?
Any what type of conviction?
Other felony convictions?
No felony record whatsoever. He had other arrests and other misdemeanor convictions, but no felony convictions. And the chief assistant testified that there were similar cases of similar magnitude, similar violence, and the lower court agreed and found this in his findings of fact on page 133 of the day 2 of the transcript.
Was there any information in the record that the people were never going to offer anything else because the complainant didn't want it, because of the nature of the crime? Again, we're talking about 25 stitches to the face based on a slashing. Was there anything in the record that came out about that?
Absolutely not. It was the reverse. The chief assistant testified his rap sheet wasn't.
The assistant that you're talking about was not in charge of this case. That chief assistant could only make a recommendation to the ADA whose case it belonged to. And that ADA said under no circumstances.
No, that's not the case at all, Your Honor.
No?
That ADA did not testify. The prosecution did not call that
Did this chief
ADA.
assistant discuss the case with the ADA? Well, did they testify to that?
The line
Did they
ADA
testify to any personal knowledge in real time about this particular case?
The chief assistant said she was not on this case. She did not know about this case. But from what she knew about the case, it was quite sympathetic. She found the case quite sympathetic. She found that the violent, again, the lower court on page 133 of day 2 of the hearing said there were cases of similar severity that warranted an immigration safer offer.
Sorry to interrupt you, but along the lines that Justice Manzanet Daniels and Pitt Burke were taking you, didn't Mr. Harold testify at the 440 hearing that he was aware of quote-unquote safer charges for immigration purposes, but that the people were insisting on a charge to assault one?
He testified he did not know. He did not even ask his immigration expert colleagues at the Legal Aid Society. He did not know what safer alternatives there were, and he declined to find out.
But if he testified that the people were insisting on a charge to assault one, where would that leave the defendant here?
So his reference to that insistence was because he testified all his communications with the DA's office were in an email, in several emails, never face-to-face, never conversations. He never informed the ADA that his client was deportable as a non-citizen, and he never informed the ADA of reasons that he should not be deported. He never made any factual.
Informed the ADA about the trauma in his defendant's childhood, and that was the reason why I think it
reduced the sentence.
Absolutely, absolutely, which shows the flexibility that the DA's office
and
had.
it also shows that the people were aware of sympathetic reasons to maybe do something else, and they were still not coming up off of assault one.
But the sentence was not the issue for deportation purposes. It was the charge. So
that's what I just said.
All right, counsel,
yes,
you'll have time on rebuttal because we're way over the time. You may proceed.
Good afternoon, Your Honors, and may it please the court. Julia Gorski for the people. I did just want to briefly correct some of the things that my adversary had said. Pages 33 through 35 and 56 of defense counsel's testimony demonstrates that he was aware of dispositions that would have had an immigration-safe alternative, such as disorderly conduct, lesser included, and he also mentioned he was aware of case law holding that attempted reckless assault is immigration-safe.
Was there a sufficient showing at the hearing that
Was that on the record?
Yes, Your Honor. That's pages 33 through 35 and 56.
Sorry.
No problem. Was there a sufficient showing at the hearing that those that the people were aware of the immigration consequence this defendant was facing?
Yes, Your Honor. So defense counsel himself testified that he knew what an aggravated felony was, that defendant was facing mandatory deportation, that he was sure he discussed the defendant's mandatory deportation with the prosecutor, and that everyone was aware that the defendant was facing mandatory deportation. The chief assistant's testimony also resonated with that. She said that prosecutors were trained to independently ascertain whether immigration consequences could be an issue in their case by reviewing the NICID report. The defense counsel's testimony corroborated that when he said in his experience, he was a defense attorney for 30 years, prosecutors were aware of a defendant's immigration status. Turning to the prejudice prong, the chief assistant's testimony, the defense is mischaracterizing her testimony. She testified repeatedly that she did not have enough information in this case to say what she would have done. And as a result, her testimony was very generalized. I would direct the court to pages 99 through 103 of her testimony. When she's asked whether or not an attempted reckless conviction would have been considered, she says, potentially we would have considered it. Again, if he is dangerous and his record is horrific and the victim talked about the case in a way that made it seem like this was not something that would make sense or was even equitable, then we would probably have not considered it because deportation might be the best thing if he is a danger to the community. I don't have enough information to say in this case what I would have done.
So in light of that statement, why is it not an appropriate result that it go back so that the district attorney's office can make that determination and assess it?
Well, the chief assistant identified the three strongest considerations she would take into account when determining whether or not deportation was an unjust result of a conviction. That was what the victim thought, the facts underlying the defendant's 7 arrests, and whether any services were offered to the victim and how he responded to them. None of those considerations weigh in favor of the defendant here. We don't know what the victim thought, but given that the prosecutor was adamant on a plea to a charge, a reasonable inference can be made that this wasn't someone who thought that the defendant shouldn't face significant prison time. As to treatment, the record demonstrates that after receiving some trauma therapy in 2005, defendant was arrested for second-degree robbery in 2009 and adjudicated a youthful offender. The rest of his criminal history as a whole demonstrates that despite receiving leniency in the past, he continued to pose a danger to the community and disregarded the law. For example, while serving his YO sentence, he was arrested for second-degree assault. He was permitted to plead guilty to third-degree assault. He was then arrested for petit larceny, permitted to plead guilty to disorderly conduct. Then he was arrested for petit larceny and grand larceny, was able to plead guilty to jostling, and then less than a year after that, he committed the instant offense. So given the seriousness of the instant offense, defendant's criminal history, deportation was a justified consequence of his conviction, and there is no reasonable possibility that the people would have offered anything else. Thank you.
Defense counsel never used any of the mitigation in this record to ask for lenience as to the charge of the plea, which is what led to this client's young man's deportation in this case. He may have asked for a lower sentence, but he never asked about what was most important to his client, which was averting mandatory deportation, and now a permanent bar to his reentry to the United States where all his family lives. Again, there's no record evidence that the ADA ever knew that this client was deportable as a non-citizen. The defense lawyer said he had never spoken to the ADA about it. He just assumed that he knew. Why? His NICID sheet listed 3 places of birth, but including the United States. So obviously if he was born here and the NICID sheet listed the United States as his place of birth, he would be a citizen. But even so, defense lawyers' duty to advocate for their client is to speak with the ADA about the consequences of the conviction and ask that any mercy or lenience that is appropriate in the case be marshaled to mitigating the very serious deportation consequences here. And again, this is a young client, a young man, first felony conviction. He had a job, he graduated high school. He And again, the lower court found that there were other cases of similar violence, similar magnitude that deserved the office's serious consideration and that received better offers that ameliorated the immigration consequences. It is hard for me to imagine a case where that would have been true, if not this case, where the client witnessed his father dismembering his mother in front of him when he was 10 years old in this country, where there were so many orders of protection that his mother took out against his father that his father continued to violate. What type of mitigation could have warranted an immigration safer deal in another case that the lower court was referencing, but not this case? It's unfathomable to me. Thank you, Your Honors.
Efren versus Efren. You may proceed.
Thank you. May it please the court, my name is Jonathan Nelson of Dorff, Nelson and Zauder, and together with my colleague, Venetia White, we represent the plaintiff appellant, Efren Films Incorporated. This appeal asks the following question of law. Can a corporation and its individual shareholder be deemed the same party for the purpose of dismissal under 3211A4? And the answer under decades of settled law is no. Not without piercing the corporate veil, and no application to pierce the corporate veil was made in this case.
What's the purpose of the derivative action?
The purpose of the derivative action is to bring a case in the name of the corporation where there's no consensus of the shareholders to do so.
Dissipation of assets, is that basically what the purpose is?
I'm sorry, Judge, I didn't hear what you said.
Dissipation of assets of the corporation?
Not in this case, no. And that actually distinguishes the main case that my colleague references, Rossignol. Rossignol, which was a third department case, was a dissolution case, which is distributing the assets of the corporation. Here, this is a derivative action which alleges corporate torts, breach of fiduciary duty, fraud, conversion.
Who were being litigated in the matrimonial action. This is nothing more than a sidestep around the rules of the matrimonial part.
No, Your Honor.
It's outrageous.
No, Your Honor.
This is the most frivolous thing I've ever seen.
No, Your Honor. Respectfully, no.
The shareholders in this particular, who are they?
They're husband and wife. Just like this.
And who are the parties to the matrimonial action?
Husband and wife.
Are there any other shareholders?
No.
So that means that in the matrimonial action, the issues concerning the underlying asset, this company, will be resolved.
No, they won't. And
yes, they will.
Judge, if you'd let me finish, no, they won't. You know why? Because the company can't be a party to the matrimonial action. So here's what can't happen in the matrimonial action. The company can't recover its damages. The company can't recover its assets. The company, as any corporate person has a fundamental right to do, can't choose to continue to operate. This court said so already. In Kelly versus Galena Bouquet in 1990.
That Kelly case, that involved a contract with a company. The person, Kelly, had a contract with the company. That's not what we have here. We have shareholders who are husband and wife fighting over things that are going to be ultimately distributed between husband and wife.
But the lower court in that case.
And I would say that that case also predates the Zhao Yan Chen case, where the Court of Appeals really set forth what is the standard when we're talking about matrimonial actions and we're talking about separating them from tort actions.
That's right. In the Zhao case, the Court of Appeals says not every case involving husband and wife should be resolved in a matrimonial action because of its procedural differences and its cause of action. Here, the corporation cannot, and that's what this court said in Sprecher versus Thibodeau. The corporation cannot be a party to the matrimonial action. It's impossible for these claims to be litigated in the matrimonial action because the company is not a party. What the lower court did.
The issue was, according to your client, that assets from one company was siphoned off into another, right?
But Judge,
Is that the allegation?
but you said my client. I represent Efren Films Incorporated. And just
Yes,
like the
and
lower...
it's your client, the wife, who is asserting this for the corporation, right?
No,
So her
because
allegations are, well, the company isn't speaking for itself, it's speaking through her in this derivative action, right?
No, Carruthers versus Jack Waite Mining, the Court of Appeals said this, quote, "The cause of action known as a stockholder's derivative action belongs to the corporation and not to the stockholders individually or collectively."
So
Court further
counsel-
explained that, quote, "The stockholder is a mere nominal plaintiff, an instigator of the action on behalf of the corporation, and, quote, any recovery in such action must run from the corporation." So no, the individual is not the plaintiff, and the Court of Appeals
Counsel,
made so.
let me read you another Court of Appeals case. Boranow versus Boranow. Let me read it to you. In a matrimonial action where the essential objective is to dissolve the marriage relationship, questions pertaining to important ancillary issues like title to marital property are certainly intertwined and constitute issues which generally can be fairly and officially resolved with the core issue. Isn't this just marital property? There's only two individuals involved. I understand there's a corporation, but essentially everything flows through them. And why wouldn't we have one court in one venue resolve the issues as I just mentioned in Boranow?
Because this is not a case where we're dissolving the corporation or we're handing out the corporate assets. This is a case where the corporation has the due process right as a corporate person to assert causes of action to recover damages. If this court affirms, it will have held for the first time that when two shareholders are divorcing, that a corporation loses that due process right, that it can't sue for its damages. This court will have affirmed the lower court, which, if I just may finish the sentence, which decided for the corporation, I'm going to decide what is going to happen to you. But it's not a party before the matrimonial court.
Thank you.
Good afternoon. May it please the court. My name is Judith Gish, and I represent the respondent along with my co-counsel, Ed Smith.
Counsel, if you could just start there and pick up that thread on the terms of the corporation being this independent entity.
Sure. I mean, that's the key question here, isn't it? The question is, and I don't dispute that in the general scheme of the law with respect to corporations, that the corporation brings a derivative action. But why doesn't it apply here? And it doesn't apply here because of the scope and breadth of the equitable distribution statute. When that statute was passed, one of the things that it did fundamentally is it said to the court, you have the right to distribute marital property as it's defined in the statute without respect to title. What does that mean? Well, that's really important in this context when you're talking about a corporation where the two sole shareholders are the spouses themselves. What it gives the court the right to do is fashion remedies, irregardless of the fact that each of the shareholders are 50% shareholders. So, in fact, we don't really have to talk about piercing a corporate veil. The statute does it for us. We don't have to hit those marks about what you would do in a regular commercial action to pierce a corporate veil. The court says in domestic relations law 236, you disregard the corporate form and you distribute the property. And I think it's really important in this particular case that we're really not talking about a statute as my adversary's brief couches it, that we're just distributing the property. It's not true. In a matrimonial action, what we're doing fundamentally is we're starting with valuing the property. So here when you make claims of looting, which by the way, my client disputes, but he'll dispute it on the merits when we get to trial. But when you're making a claim of looting in a matrimonial action when it comes to a corporation, how does that issue evolve? Well, it evolves really in two ways. It involves in the fundamental question of what's the value of the corporation, right? If somebody's looting a corporation, then the value of the corporation takes in forensically the value that's been looted and adds it back, and that's distributed to the parties.
I just have one question. Would it matter if there were 3 shareholders, 4 shareholders?
Yes, I think it would. I think it would limit the court's ability to make distributions, but here there is no such limitation. Which really what we're trying to do here is prevent the wife from bringing a secondary action on the same facts that ultimately will create a havoc and will possibly create inconsistent results in 2 different cases and getting a second bite at the apple on what are essentially the same claims.
Would we be the first appellate court to condone the consolidation of this kind of claim with a matrimonial action?
Well, we're not talking about consolidation. We're talking about that the matrimonial action takes care of it. And I think it's really done all the time, and these objections really aren't raised, because let's look at what the matrimonial court can do. And we've seen them in these cases. They have a corporation. The court orders that one party get 100% of the shares and the other party gets paid out, or vice versa. Or in Rossignol, that the corporation is dissolved. The corporation, there wasn't a dissolution proceeding in front of it. It can order that the corporation be sold. It has various substantial remedies that it can do in terms of the corporation. And I think it's really important to understand that this idea that the corporation has some right of self-determination, well, that right is really lost once you bring a matrimonial action. Unless the parties decide what to do with this corporation by mutual agreement, the future of that corporation rests entirely in the hands of the judge deciding the matrimonial action. Likewise, the idea that the corporation loses its discovery rights, it's not true. There is unbelievably robust financial discovery on marital assets, which this indisputably is. And quite frankly, the judge in this case said to the plaintiff when the matter came before him, he said, I'll give you whatever discovery you want regarding the corporation and the Canadian corporation and the sale that was there. So we have to really think about what was motivating her to bring this action when she could get full relief. One last thing that they do argue that the poor corporation gets to lose is this idea that somehow they have a right to a jury trial in a derivative action. And I would just point you to the mayoral case, which says that derivative actions are, you said, derivative actions are equitable in nature. So there really is no right to a jury trial. So these rights that the corporation is crying about losing are really illusory. And really all the wife is really trying to do is to enhance the value of the corporation in order to get a bigger distribution of her share. Thank you very much.
Thank you. Counsel, you have 2 minutes.
If this court affirms, it will hold for the first time that a corporation loses its right to sue in its own name whenever its 2 shareholders are divorcing. It would mean that any married couple who incorporates together loses the protection of corporate personhood the moment one of them files for divorce. That's not the law.
Sir, how do you answer your friend's point that there's a real risk of inconsistent judgments if there were 2 separate proceedings?
I didn't appeal the consolidation. We're in front of the same judge. We're in the same case. So there's no chance of that.
Counsel, outside of this Kelly case, were there any other cases that you cited to where, in this particular situation, where it's a husband and wife having a company together, it doesn't even have to be a company such as this, but any kind of business, where there's a separate action for the distribution?
You know, Judge, I didn't find one, but the Kelly case, I have to say, is spot on. Now, I understand that the parties were a little switched, but this court flatly rejected the argument argued by my adversary and said, we have no such defense in this state, nor will this court create such a defense. The amorphous right that my colleague speaks about is the due process right of a corporation to go to court. The corporation is not a party to the matrimonial action. So this corporation would have fewer rights than any other corporation in the state of New York, not because of anything it did, and not because there was any challenge to the derivative complaint, but because its shareholders are divorcing. This
In your opinion, would it matter? I guess I'm not sure. I guess not. If it was 3, maybe 4 shareholders, does that create something different, or does it's just enough that it's a corporation?
It's enough that it's a corporation. The Supreme Court of the United States over 100 years ago declared a corporation a person, and a person has due process rights. And to say that, well, you know, the wife or the husband is in the party, is in the case, the corporation isn't. And if this court affirms, it will prevent a person under the laws of the United States due process to appear in a court for the first time.
Thank you. Countrywide Insurance versus National Indemnity.
Good afternoon, Your Honors.
Good afternoon. You have 4 minutes.
I will try to make it even faster and obviously respond to any of your questions. This case is a mess. I understand that. But here is, in the record, page 298 and then 299 and 300 is the way you're supposed to add a vehicle to an insurance policy. This is not rocket science. Your agent calls the insurance company or their agent. You say, I'm adding this other policy. They issue an endorsement, and they issue an insurance card, and you get it, and you're off to the races. That was done for this policy. As I said, on page 298 of the record, you see this actually being done, and the insurance company's agent actually issuing properly insurance cards, and which is not what happened for this vehicle. The vehicle involved in this loss was never passed on to the insurance company. No endorsement was issued. Obviously, no cards were issued by the insurance company. The cards were issued, apparently, by the insured's own agent, which had no authority to do so. And the bottom line is, again, the judge below was all over the endorsements. He cited to the endorsements. He knew about them, and then just went off and decided that this unauthorized card was going to change the picture. And I cite the court to, in our brief, we cited to the Yeshiva Gedola versus Church Mutual, I love that citation, which said that it doesn't matter. You have to add an endorsement to the policy. You can't change a policy by unilaterally, by having the insured or its agent issue an endorsement, which is what happened here. That's all I've got.
Thank you. Specchio versus Starbucks Corporation. Okay. You already heard my spiel before, okay? All right.
This is for the prior case? Or?
For this case.
Oh, I thought it was a prior case. You steal a chair. You got three on this side.
That's what I was saying.
I thought so.
So defendant Starbucks and Shamut are the... And you asked for 6 minutes. You asked for 6 minutes.
Yes, Your Honor, and I probably will be significantly less than that for a number of reasons. May it please the court, Steve Gustafson of McCormick and Priori on behalf of Starbucks and Shamut. Very quickly, this is a situation where there are multiple issues of fact. We think of the beginning of every jury trial when they say you're entitled to, believe anything from a witness. You believe what they say, everything, or if any of it. And when we're looking at these motions, we respectfully suggest that sometimes very little is worthy of believing. It's an issue of fact as to whether this was a work area or a passage. It's also been referred to as storage area, this area which is not even really properly described as a room according to plaintiff. So plaintiff testified that there was an 8-foot by 8-foot and 2.5-foot high pile in which he slipped on the edge when he was talking about how much room there was on the other side of the pile in the room/area. At first he said 2 feet, and then he said, no, 2 feet isn't enough. So we have an indeterminate nature of this area/room.
Isn't the issue whether there was debris that should not have been there that caused his fall? Isn't that the issue?
Well, I was discussing the issue of whether it was a work area or a passageway or not, but the issue of debris is also an issue of fact because, as a matter of fact, Dow salvaged it, took it and salvaged it, and
Was there anything in the record that, my first question, I don't mean to cut you off, but the plaintiff was going into this particular area to retrieve materials that he needed for his work?
he was going through the area to retrieve material, is what it says. It's
So
been
then it's,
argued
is it
whether it's a passageway or a work area.
Because I thought it was that he was retrieving materials that were there. And then my second question was there anything in the record that indicated that these materials that were piled were going to be used again on this particular project?
Well, actually, they were salvaged, but the issue of whether something is integral or not, plaintiff had no idea how long those materials were there. At one point, he said 15 minutes.
It's not important for him to know. It's important for the defendants to know how long it was there and whether they had a sufficient amount of time to remediate the problem. Isn't that
that's an issue with how long it was there. But the thing is, on the issue of whether it's integral to the work or not.
So counsel, the law has changed on that. There's the Basdaric case that you know about, and the standard is whether it's impossible to complete the work, and obviously it was possible to put the material in a different way so he didn't have to trip on the debris while he was reaching for the panel that was against the wall.
Well, still, can you do it without it? I mean.
So it wasn't impossible to get there. So obviously there could be another mechanism where the defendants could have moved this so he didn't have to be.
It wasn't possible to get there, Your Honor?
So the standard is impossibility. Can the work have done it any other way? That's the standard, impossibility.
Well, okay, so they needed.
The standard that you cited isn't correct. It's been changed by Basdaric.
Mongo wire of a certain amount, and then they had to cut it. And then when they cut it and they take the long piece to do what they're doing with it, and they put the other piece in the pile of discards, which is going to be salvaged, does it instantly become not integral to the work when they
It wasn't integral to the plaintiff's work. He wasn't doing anything with those pieces of discarded, I believe it's electrical wiring.
And
that was not part of his work.
And he had to go through the area, as he tells it, and he had,
No one has contradicted that.
He had over 2 feet in which to walk, and he was carrying nothing on the way out.
24 inches is not a whole lot of space, so it should be clean.
He said over 2 feet, so it's somewhere above 24.
3 feet, 24 inches, 36 inches, it should be clean, and it wasn't.
He said he hit the thing that, as he put it, he rolled it at the very edge of the pile. So he had a couple of feet, and he was carrying nothing, and he was looking at the pile as he described it, and he fell.
Comparative negligence then, and how would we view that?
Well, I don't know. That's for the trier of fact. How would a jury view that? Would they say that it's negligence? Would they say that it was negligent for Dow not to have?
So counsel, under Rodriguez, we don't even get into that equation. That goes for the jury. There will be liability of the defendants. Then later at trial, it's a separate question. So that's not liability, that's damages.
Well, it's also has to do with indemnity issues that we have here.
Indemnity has nothing to do with liability.
Well, it's, as I say, an issue of fact as to whether it was integral to the work at the point that it was cut off. Dow salvaged the material. As far as Shawmut being obligated to clean it up, this particular material, because it was salvageable, there's no testimony it was ever picked up, normally or in this case by Shawmut. In fact, it was Dow that picked it up. So plaintiff arguably shouldn't have fell there.
Right, counsel, you have to wrap it up because we're
Yeah,
out of time.
and there's a wealth of issues of fact here, and they could be argued different ways strenuously.
Thank you. Okay.
May it please the court, Michael Cassell for the plaintiff respondent. Essentially here, I mean, the court doesn't really need to look any further than defendant's own statement of facts, which says that the plaintiff walked towards the panels behind the discarded electrical cable debris. It goes on to say that the plaintiff fell due to the presence of cable debris. So we have debris, we have a working area, we have a prima facie entitlement to summary judgment. Defendant puts forth nothing in response. So with nothing in response, there's no question of fact to defeat summary judgment.
What about this issue of the salvageable, I don't even know what to call it, wires?
Sure. So as Justice Hagler providently pointed out, if it goes to the integral to the work defense, it's no longer a defense because the standard under Bisdarek is, I submit, is pretty high. It has to be a showing that there were no preventive means to makes it impossible for the plaintiff to perform his work. So using preventive means. So defendants would have to show there was no way, there was no means that they could have put in place for which would have protected.
Did defendants show any of that? Did
No, I
defendants
mean-
come forward with any evidence that could have been done, that they had to have this in this particular way for the work to be done?
No, I mean, the plaintiff was just walking. I mean, in Bisdarek, at least, there was arguably, they put the plastic down on the escalator, and the plaintiff was working on the escalator, so that maybe, but of course, the Court of Appeals said even in that situation, because it wasn't impossible. It has to be impossible for the plaintiff to perform his or her work. This is just debris sitting in an area where the plaintiff has to go to get these panels. So it can't be integral. As far as whether or not my client should have avoided this pile, it doesn't matter. It goes to Rodriguez. It's still summary judgment. And does the court have any questions? No? Thank you for your time.
Thank you. Gentlemen, you're next.
May it please the court. Excuse me, David Goldman for third-party defendant responded to Eclipse Contracting. It's respectfully submitted that the lower court properly granted my client respondent Eclipse Contracting summary judgment. I know counsel didn't really get into his arguments, but just to mention what, in terms of his brief, the plaintiff did trip over wire, this is undisputed, that was not part of Eclipse Contracting's work, nor was there any evidence Eclipse was responsible to clean up for the other trades. It's also undisputed that any debris or garbage at this site, including electrical debris, was the responsibility of the laborers from Shawmut Construction, the general contractor. Multiple witnesses from all parties testified with regard to this issue, including the Shawmut construction supervisor. If the court has any questions, I'd be happy to answer.
You got it.
Thank you.
Counsel, you have 2 minutes.
May it please the court, my name is Jessica Price. I'm with Milburn Macris, representing DAL, the third-party respondents. Just to piggyback on Eclipse's arguments, despite whether it's a workplace or not, Shawmut was responsible for picking up all the debris on site. As the lower court had already found, DAL had center piled its debris and complied with its contractual obligations. Shawmut was then responsible for cleaning up any debris, and to the extent that plaintiff fell on any debris that was in this basement, it would be Shawmut's responsibility to clean.
How about the indemnification clause? Doesn't it make Dow responsible for any injury arising out of his work?
Yes.
Wasn't the electric cable part of the work of Dow?
We submit that it was not, because this is debris, right? We had finished with
But
the
who
work.
created that debris?
they had created the debris, but once it's debris, the work is not ongoing, right? They placed it in the center, they center piled it, their contractual obligations was to center.
Is there any question of whether or not it was piled correctly or piled in a way that people don't trip over?
There was no testimony or any complaints about the way that the center piling was done. If anything, there was all the witnesses, even from Shama himself, said that Mr. Avidabelli, I believe is how you say his name, he came forward and testified that it might not have been specifically in the center of a room, but if as long as they were neatly piled and kept, that's what everybody complied with at the site. And that regardless, Shama was responsible for cleaning up those debris piles.
Thank you.
Okay, thank you.
All right. I think that's all we got. You didn't reserve any time. You asked for 6 minutes, and I repeated it to make sure that, okay, you just asked for 6. So I take your time request as you give them. Thank you. Roth versus Velasquez.
Good afternoon. May it please the court. Jacob Bentley for Dr. Velasquez and NYPH Columbia University Medical Center. Plaintiff's theory, said in the most simplest terms, is that a CT angiogram should have been done on November 10th, and had it been done, a pulmonary embolism would have been diagnosed and treated. However, to purport that theory, one must ignore, and in fact, plaintiff's expert, Dr. Mayer, does ignore, defendant's radiology expert's opinion that the December 22nd imaging revealed an acute pulmonary embolism, one that was not present on November 10th. Plaintiff's expert does not address in his affirmation this imaging specifically. He says he believed that it was an older pulmonary embolism that existed from November 10th due to the continuous nature of plaintiff's symptoms. However, it's not enough to merely disagree with a defendant's expert's opinion. A plaintiff's expert must specifically address and rebut the specific facets of this expert's opinion, and Dr. Mayer did not do that.
Well, was he wrong in saying that the CTPA is the gold standard of testing for PEs? Is that wrong?
Whether it's...
And did your doctors contest that?
No, Your Honor. What the issue is whether they deviated from the standard of care for emergency medicine.
I'm getting to that, which is why I asked the question. So now you're going to answer my question before you give me your argument. Did any of your doctors contest that the CTPA test is the gold standard for diagnosing a pulmonary embolism?
No, Your Honor.
They didn't contest it, right?
No.
Okay, and it wasn't done.
It was not done on November 10th, correct?
Right.
The reason it was not done, according to defendant's emergency medicine expert, was because based on the combination of the testing, the imaging, and the inherent risks in that procedure. Plaintiff's expert, Dr. Mayer, does discuss the D-dimer. He does discuss the imaging. He does not discuss at all the risks in that procedure, which can include renal failure or radiation to the chest. Once again, it's a case of plaintiff's expert.
Well, he got radiation, right? Because they did a CT scan of his lower abdomen. So they didn't protect him from radiation. Instead, they didn't take advantage of that first CT scan and scan both areas like the plaintiff's doctor suggested. And I saw nothing in the defendant's response to explain why that wasn't warranted, why a man who walks into an ER with 8 out of 10 chest pains, right?
Correct.
Why you wouldn't just include, if you're gonna CT the abdomen because you think it might be a kidney stone, why not CT the chest while you're at it? You're in the same basic area.
Well, it's a fair point, Your Honor, but according to defendant's emergency medicine expert, the D-dimer and the CT of the abdomen, plus the risks, which include renal failure, of the CT angiogram, did not indicate that a CT angiogram needed to occur in this case. And once again...
Counsel, isn't it true it's much more than that? We had shortness of breath. A week earlier, there was some sort of procedure which was emblematic of PE. and also the Wells score went up to 7.5 after they discounted the kidney stones. So all that together would lead one to believe that you're missing something, which would be, as my colleague just mentioned, that simple CT scan of the chest while you're doing the CT scan of the abdomen.
Yes, Your Honor, all of that was considered by defendant's expert, but he still reached the opinion that the CT angiogram.
Doesn't the plaintiff's expert opine that was the departure and the proximate cause of the injuries that occurred later?
Yes, that is his argument. He does not discuss the risks, nor does he discuss the imaging on December 22nd that, according to defendant's radiology expert.
Can you answer my colleague's question? What would have been the difference of radiological exposure between a chest CT and an abdomen CT? You're there anyhow. It's the same. It would be minimal. No one even explained that.
It'd be the defendant's emergency expert, emergency medicine expert, excuse me, felt that the combination of risks plus the presentation did not mean that a CT angiogram was indicated. And if I have time, I would like, I don't have time.
We'll have time on rebuttal. You hit us later.
Good afternoon, Your Honors. Thank you for bringing up that point, Judge, with respect to the exposure to the radiation in any event. Mr. Roth is a quintessential New Yorker. I mean, the guy is a hard-charging guy. I mean, the guy was doing 250 miles a week on his bicycle, and he had this episode, and he goes to the ER at 2:30 in the morning, and he hopes that the ER doctors are going to do right by him. He shows up with all of these different ailments that are indicative of a PE, and they go and they look for a kidney stone problem. It's ridiculous. So the first doctor that want to say something, Judge?
Oh,
the first doctor, Dr. Velasquez, set them on this course of looking.
Was he the first doctor, or was someone else that?
There was another doctor that initially interviewed him, but Dr. Velasquez was his resident, and he took over. And then when he changed shifts at 8 o'clock, he never reported all of these PE problems to the following.
So the first doctor that saw him,
yes,
which was Dr. I can't spell the name. Suguitan.
Yes.
Right. So when he sees the patient at approximately 4 a.m., his note indicates that at that time he's not experiencing any chest pain. His complaints are of right rib cage pain.
Right rib cage pain, yes, Your Honor. And
right.
He was given some pain medicine during that time period, which could have masked a lot of those pain symptoms. And the other thing was that he had the EKG, which also showed a improper or a compromised RBBB score.
And wasn't it that first doctor that, in essence, set the treatment plan for Mr. Roth?
Well, he was the one that initially interviewed him and took his information, but it was Dr. Velasquez, who was the resident there, that really took charge of the situation, and he passed along the information to the people.
What time did Dr. Velasquez first see this patient?
I don't have that off the top of my head.
6 o'clock or so, according to the note?
Yes, Judge.
So the first doctor sees him approximately 4:20 something in the morning,
yes,
and he sets the treatment plan, and then
yes,
approximately an hour and a half, almost 2 hours later, Dr. Velasquez sees him. And again, at that time, he's not exhibiting any shortness of breath, no chest pains, and his complaints are to the right rib cage.
Right rib cage, exactly, Judge. But you got to remember that when he initially came in, he was complaining of a very high, sharp chest pain, 8 out of 10. And although it dissipated over time, he's in a hospital setting. He's being given painkillers, and that's going to be
Yeah, but my question to you is, if when Dr. Velasquez sees him, he no longer has the chest pains.
Yes, Judge.
Because now he's only complaining of right rib cage pain.
Right.
Right? And someone else has already set a treatment plan, and he's only going to basically follow up on that. And then he leaves at 8 o'clock in the morning, right, and someone else takes over for him, and in essence continues with the treatment plan that was set by the first doctor.
Right. But
what is Dr. Velasquez's departure here?
He's the resident judge. He's the one who is in charge of the ER at that juncture.
What was he supposed to do is the question. What did he fail to do that constitutes a departure such that this case should continue against Dr. Velasquez?
Well, Velasquez is in charge, and he's the one who should look at the totality of the circumstances.
Look, being in charge is not the answer to this question. That alone doesn't win the day. You have to tell us, what is his departure? What did he do? Did he fail to understand that the first doctor's treatment plan was inadequate? Did he fail to add to? You got to give me more than
That's it,
he
Judge.
was the boss.
No, well, that's it. He didn't look at the initial complaints and include those in his treatment plan that should have adjusted. I mean, when you see someone come in with with chest problems like that, and you send them down for a kidney stone,
Well,
it doesn't make sense.
But that's what the first doctor said. He said, I suspect that this is what he's having. And that's what the treatment plan that he, in essence, created said, let's look into this. So when Dr. Velasquez sees him, and now they're suspecting a kidney issue, why would he order a CT scan with contrast that could have a possible effect on his kidneys?
Well, he shouldn't. You're right, Judge. He shouldn't do that himself, but he should pass along the information showing that there was major chest problems from earlier, and it's something that should be considered. Once they found out he had no kidney problems, they washed their hands of it.
Yeah, but by the time they found out that there was no kidney problem, Dr. Velasquez was home.
I understand.
He was long gone. And it was the next doctor, Dr. Jiang, who then ordered the CT scans, et cetera. So you've got stuff that happens before, stuff that happens after, and all that happens in between with Dr. Velasquez is that he examines him one more time and does not confirm any chest or no chest pain. The
He
man did
fails
not
to
complain
look
of
at
any
the
chest pain.
totality of the guy's circumstances and pass that information along and say to the next group, listen, if this kidney problem comes back negative, you got to do another D-dimer. You got to look at this possible PE. That's his responsibility as the resident in charge.
Why wouldn't the next doctor who comes on shift, why isn't it that doctor?
It's his
Let me finish. Why isn't it that doctor's responsibility to look at the notes the same way Dr. Velasquez had to? Doesn't the next doctor have to look at all the notes, the triage, the first doctor and Dr. Velasquez? Don't they have to look at each other's notes?
Absolutely, Judge.
Okay. Did he not leave notes? You're saying his notes were bad?
I'm saying his notes were not comprehensive.
Okay. All right.
I'd like to return to the topic of Dr. Velasquez. Beyond the points Your Honors made, there's also no causation argument against Dr. Velasquez. As Your Honors mentioned, he was home when the decision about whether or not a CT angiogram should happen occurred. Dr. Mayer, plaintiff's expert, agrees essentially with the order of operations that occurred here, that a CT scan of the abdomen, a D-dimer, no one disagrees that all of these things were indicated and should have been done. The disagreement...
Counsel, isn't the problem with differential diagnosis, the only diagnosis that Dr. Vasquez had made previously was the kidney stones? He didn't even contemplate a more possible diagnosis of PE, and that initial failure to document is what the plaintiff's expert said was the problem. Isn't that the case?
That is the case, Your Honor. However, even if it was a deviation from Dr. Velasquez, there's still no causation, because as the record demonstrates, they still would have done this D-dimer, they still would have done the CT of the abdomen, and the results would have been the same.
But if Dr. Velasquez had ordered a CT of the chest,
and that's
the embolism, it's, a delayed diagnosis, right?
Yes. Hypothetically, yes, Dr. Velasquez could have ordered a CT of the chest at 8 a.m., but once again, the chest pain had subsided by then. The main issue was the rib. In the ER, they treat the most pressing issues first.
And I think the real important thing is here not what we're batting around or what plaintiff is claiming, what is supported by plaintiff's experts' affirmation. And in your view, what is the deficiency or defects in Dr. Meyer's opinions vis-a-vis Dr. Velasquez?
Dr. Mayer does not link Dr. Velasquez to the decision whether or not to do a CT angiogram. They all agree that the D-dimer, the CT of the abdomen, the order in which this occurred was all fine. The issue comes when Dr. Mayer says more should have been done. Defendant's expert says they shouldn't.
Dr. Mayer's test affirmed that there was a departure by failing to note a differential diagnosis of PE and failing to do that chest CT. That's what he said.
Yes, Your Honor.
Thank you.
Thank you.
People versus Sammy Martinez Jaques. Last but not least. Ladies, thank you for your patience.
Good afternoon. I'm Catherine Martone on behalf of Mr. Martinez Jaques. The hearing court erred in this case in denying suppression because no evidence demonstrates the reliability of the information that purportedly justified the stop.
We're looking at the totality of the circumstances.
Yes,
now?
that's what the Court of Appeals instructed or clarified in its recent decision in People v. Layton R. The court must evaluate the value of anonymous information, an anonymous tip, under the totality of the circumstances. And here, at page, here, Officer Knott relied on the police dispatcher's information regarding the description and travel direction of the vehicle. And at page 10 of the hearing transcript, starting at line 19, we have just what Officer Knott heard over the transmission. He knew that it was a carjacking from New Jersey, a black Toyota with Pennsylvania plates, and that the vehicle was moving in the proximity of West 165th Street and Amsterdam Avenue. And the problem with that proof here is that, you know, it's been the case for a long time now, since the Supreme Court decided Florida v. JL about 25 years ago, that in cases involving an anonymous informant, an accurate description of the subject's appearance and location by itself is not enough.
If we were to add the testimony that the officer inquired from the parking lot attendant that did a black car, I don't remember if you said Camry, but a black car with Pennsylvania plates just enter into this parking lot, does that bring the totality closer to what we need for the gunpoint stop?
No, not at all, because that information is related to describing the vehicle and the location. It is not relevant, does not go to whether the assertion that the vehicle was involved in a carjacking was reliable. That's
So, counsel, are you arguing absent a description of the defendant that allegedly did the carjacking, this would be all unreliable?
no, I'm not arguing anything about the description here.
So what's missing?
What the court needed was, and really here, the guideposts for this case are People v. Walls and People v. Layton R. Because they give the court the type of facts that are relevant in making the determination as to the reliability of the information, in assessing that under the totality of the circumstances.
In Layton R, I thought the contemporaneousness of the proximity of where the car was and where they apprehended the defendant is one of the key factors. And we have the same thing here. It was within seconds they responded to this call, the transmission call.
Okay, so that's exactly right, Your Honor. The contemporaneity of the report was substantial in Leighton R. And what is so key here is that because the prosecution didn't establish anything about the report, the source of the transmission, we don't know when it was alleged that this carjacking actually occurred.
In New Jersey.
In New Jersey. There's no evidence in this record whether it happened 10 minutes ago or 2 weeks ago. The record, this is a really unusual case where the prosecution didn't put in, we don't even know if this was a 911 call. They didn't put in the call itself. They didn't put in any evidence about the content of the call.
But counsel, when the detective testified, I forget his name.
Yes.
Not no.
Oh, I'm sorry.
Walters. When Detective Walters testifies, he says that he spoke to the complainant, and who said that his car was taken from him on Dyckman Street, at the end of Dyckman Street, by the pier. And that, I believe, is the car that we have here, the black Toyota.
That's a different car.
Because he's the one that went then, taken by the detective, and shown the lineup.
Yeah, that's the first incident. And so then there's a second incident that follows that.
So the items that were found in this vehicle, weren't they the items of a Mr. Martinez?
Yeah, they were the items of Mr. Marquez. His items were in the car, but it wasn't his vehicle. So there was a second incident. The vehicle I'm sorry, Your Honor, but the vehicle here is not the vehicle that was involved in Mr. Marquez's incident.
So the incident occurred on June 29, 2016. Is that correct?
I'm sorry, say that.
The date, there were two different alleged carjacking. One on June 27, 2016, which you said Mr. Marquez was involved. That was a Honda Odyssey.
That was the first.
Right, and that's the first one. The second was June 29, 2016. I can't remember, Brian Balbera, I can't pronounce the name correctly, was a Toyota that was involved, and that was on June 29th.
Yes, Your Honor.
And wasn't that the same time and the same date as when the officer approached the black Toyota?
Judge, all I can say is that on this record, there's no proof as to when the carjacking that's at issue here allegedly occurred.
If I may, the carjacking on the 29th, there wasn't any temporal proximity given to that, but we do know that on June 30th is when the arrest happened.
Right.
Hey, you'll have time on rebuttal.
Good afternoon, Your Honors, and may it please the court. Julia Gorski for the people.
Do we know what time the June 29th carjacking happened? What time was that?
So it was in the early afternoon. The car was stolen from the victim in Upper Manhattan. The defendant drove that vehicle to New Jersey. The car ran out of gas. He parked it on a stop on the New Jersey Turnpike, stole the vehicle from Balbuena, drove that back into Manhattan. That is the subject of this radio transmission.
Can I clarify? Are you
All
saying
of those details were in the radio transmission?
No. I'm just explaining which car is which.
So the June 27th was the Honda,
Odyssey? Yeah.
the Odyssey?
Yes.
That's the one that was stolen from Manhattan, driven to
New Jersey.
New Jersey.
Ran out
And
of gas.
another car carjacked on June 29th. That's Balbuena's car.
Yes.
Back to New York.
Correct.
That was on June 29th. Was the car? What time on June 29th was that carjacking?
That was around 10 or 11 p.m.
And what time was the police contact here?
Shortly after midnight
On June 30th?
on the next day.
Would be June 30th, right? 29:30, that's how that goes?
Yes.
If we're going to look at it under this Leighton R case, are we saying then that that's contemporaneous, right? Because you're telling me that there's at least a 2-hour, maybe 3-hour, maybe more, who knows? Because we don't know.
Right.
At least we don't know from the radio run, from
Right. So
what was the temporal.
I don't think we even need to get there because the officer responding to the radio report did not know exactly when these cars were stolen. He just received a radio report.
Isn't that the point?
No, and
No, that's not the point?
I'm saying that the contents of the radio transmission itself demonstrates prior police verification and reliability. The fact that this was a New Jersey carjacking, it's an out-of-state crime. If a 911 caller calls 911 in New Jersey, they're not connected to a New York State operator. Second, the car was being tracked in real time.
I understand that, but the problem is once you have New York police officers responding, then our assessment is what information did they have and when? And at the time of the gun-drawn stop, what is the information they have? Because that's what's relevant, what they knew when they pulled that gun to stop that car.
Yes. So
Right?
they had the information in the report, which was the black Toyota with the Pennsylvania license plate and the actual real-time location.
Let me ask you about this Pennsylvania license plate. When the police officer approaches the vehicle, had he seen the Pennsylvania license plate?
He had not. However,
Because there was no license plate on the front of the car, correct?
correct.
And he was approaching from the front,
Yes.
correct? And he pulls his gun out, stops this vehicle that he doesn't know has a Pennsylvania license plate.
He did not
There
himself.
wasn't any testimony from him that, or was there, that that's the car right there that just pulled into this lot. It has Pennsylvania plates. Was there anything like that in the record? Because I
So-
didn't see it.
No, but he did speak to the parking attendant who confirmed that a black Toyota with a Pennsylvania license plate had just pulled into the lot. And immediately thereafter, he saw the car pulling to exit the lot.
So a car that had just pulled into the lot was now exiting the lot, and you can pull your gun out, tell that car to stop.
How does he know that that's the vehicle that had recently pulled into the lot?
Well, so again, the real-time tracking here. So I think this also lends towards the reliability of the transmission. The police cannot just track a car in real time without some involvement from the car owner to access a GPS or other tracking
Counsel,
device.
where is there testimony about this real-time discovery of this vehicle? Because that's the missing link, and I was curious myself.
There's more than that in this, more than that.
One of the things.
So at 12:30, he receives the radio transmission reporting a carjacking in New Jersey and that the car being sought is being tracked in real time. He reported that the vehicle was moving, it was in the
Where did he get the information was being real, that
the radio transmission. So the question is, was this transmission being given in real time? Yes. And how did you know this? They were tracking the vehicle. They
who
were
was
saying-
tracking the vehicle?
It's unclear. But the
Was
dispatcher
the police
said,
tracking the vehicle? Was the owner tracking the vehicle?
I think the logical inference is that it was the police.
Wait a minute.
And there's no
Wait, please. Logical inferences don't meet the standard. You realize that. So we need concrete evidence, because at the end of the day, fast tracking, GPS tracking the vehicle that goes into, that's the only black Toyota in all of New York City on that night in that garage?
No, Your Honor, but
Exactly. So tell me how it is that on the basis of this record, a police officer can pull a gun at a driver exiting a parking garage without more.
okay. Within moments of receiving the report with the description of the car, he spots the car in the parking garage. It is 12:30
He
at
spots
night.
a car
And
in the garage, because he still hasn't verified that there was Pennsylvania plates on this car. He still hadn't verified that.
Correct, but he hadn't stopped the defendant at that point. So he's on the street looking at the outside parking garage. He sees a black Toyota. The defendant is standing immediately in front of the rear license plate. He continues around the block and goes to the entrance of the parking garage. He asks the parking attendant whether a person driving a black Toyota with a Pennsylvania license plate had recently pulled into the lot. The parking attendant says yes. At that moment, he sees the same car and person driving to
Did he see?
Wait, the same car that he saw on the other side that he couldn't identify. So you're trying to connect a observation that is not damning, right? It's a black car.
Correct.
The officer hasn't confirmed a Pennsylvania plate yet. So all he sees is a black car. So when he comes around and sees a black car exiting, that's all he sees is a black car.
He testified that he saw the same black Toyota driving to exit the lot. And at that point, he had to make a decision. It was, I believe, reasonable to stop the car at that point.
At gunpoint.
Gunpoint.
He couldn't just stand in front and say, "Stop, I need to talk to you."
He could have, but he also knew that the car was stolen as a result of a carjacking. So as a precautionary measure, he did.
Did he know that a gun was used in the carjack, or is carjacking just a term of art in police work that it necessarily included a firearm?
I think typically it includes some type of weapon.
Was there a report of a firearm? Because not all carjackings include a weapon.
Just the
Sometimes
carjacking.
they just open the door and pull you out and throw you on the street and jump in your car.
It was just the carjacking.
Okay.
Thank you.
All right. Any other questions? All right, time on rebuttal.
Just briefly, as to the reliability of the allegation here that there was a carjacking, of course, we can't look to the trial record. We know that there was a carjacking in the case. The question is, what did Officer Na know at the time he made the stop? And based on this record, we don't know anything about the report, who made the report of the carjacking, when they made it in relation to when the incident occurred, whether a gun was involved. We don't know anything.
Well, if we put aside, I guess, in my day, what they would call the Aguilar-Spinelli inquiry, right? Put that aside for a moment.
Okay.
Would you agree that at the moment the officer drew his gun, that was a level 3?
Yes, that was.
Okay, so putting aside the issue about the reliability, let's assume for a second we're going to consider that, what the officer heard on the radio report. Where was the failure in the requisite showing on DeBoer level 3 at the moment the officer drew his gun?
We needed to know that the allegation that there was a carjacking was reliable. And in deciding whether that allegation of illegality is reliable, the court is to consider who made the report, whether it was an identified citizen or an anonymous reporter or a person who claimed to be an acquaintance of the defendant or something. We need to know what their basis of knowledge
Let's say it was reliable. Let's assume for a moment, just assume, that we find that it was reliable, okay? If we did, is there still a failure at DeBoer level 3?
Judge, I'm sorry.
Would there need to be some other kind of corroboration?
You would need to be able to find that this was reliable in order for this stop to be justified. That's essential. And that's putting aside the issue of whether this was the black Toyota that was described in the radio transmission. You need to find that the carjacking allegation was reliable. You can't look to what was the trial testimony. You can't look to what Detective Balbieri or Walters knew. You can only rely on what Officer Na knew when he pulled out the gun and ordered the car to stop. And as the court said in People v. Layton R., the Aguilar-Spinelli basis of knowledge and reliability factors still come into play, the court needs to decide under the totality of the circumstances whether they've been met. There's absolutely nothing in this record that could allow you to conclude that the information was reliable, because we just don't know. This could have been an anonymous informant who, based on secondhand information, was saying,
saying that at the time of the stop, the officer conducting the stop did not know who made the complaint of the carjacking, what the basis of that complaint was, whether it was the victim themselves or somebody else who saw a carjack. We have no idea.
No idea.
And there's no evidence in the record that Officer Na knew.
That's right. I mean, this could have been something that happened 2 weeks ago, for all Officer Na knew.
Got it. All right, thank you. You okay?